Supplementary list item number 1 for judgment.
After having carefully gone through the Supreme Court's decision in case of Bakshi Singh, we are of the considered view that this case is clearly distinguishable on the facts and law both. As has been noted here in above, the facts are not in dispute that the respondent remained absent from service unauthorizedly with effect from 1 to 1997 till the initiation of departmental proceeding in February 1998. He did not participate in the departmental proceeding despite service of notice upon him. The inquiry officer found the charge of misconduct of unauthorized absence proved. The disciplinary authority, agreeing with the finding of the inquiry officer, imposed punishment of dismissal from service on 14/5/1998. More than 8 years thereafter, the respondent preferred an appeal on 1/6/2006 before the appellate authority, taking a plea of his mental illness and treatment therefore under a psychiatrist at Ranchi. There is no pleading or any document to demonstrate that the respondent was ever hospitalized for treatment in any hospital during the period when he overstayed the leave period. He did not bother to intimate his whereabouts to his superiors during the intervening period, which stretched up to around more than a year till the order of dismissal was passed on 14/5/1998. More than 8 years thereafter, he preferred the appeal against the order of disciplinary authority, which in court's opinion was rightly rejected by the appellate authority on the ground of delay. The overstay of the respondent beyond leave and in the facts and circumstances of the case as noted above is a serious misconduct for a member of a disciplined force like CISF, which cannot be countenanced. The respondent was given adequate opportunity to participate in the departmental inquiry. It is difficult for this court to accept the stand of the respondent that his ailment was of such nature that he could not even inform about it to his superior officials during the pendency of the departmental proceeding, and for 8 years after the order of dismissal was passed. In our view, thus, the impugned judgment of the learned single judge requires interference. The appeal is accordingly allowed. The impugned judgment and order dated 9/2/2021 passed by the learned single judge in WPC number so-and-so is hereby set aside. The writ petition is dismissed. There shall be no order as to cause. इसको judgment के form में देना था ना.
Lordship had the matter
Yes, sir.
yesterday, madam. That compulsion upon me.
Physical file. The Union of India.
I am for the opposite party.
We are dictating the order.
Loss. Sorry, ma'am.
Take your seat.
Your loss.
The Union of India. In the present petition filed under Article 226 of the Constitution of India has questioned the legality of an order passed by the Central Administrative Tribunal, Cuttack Bench, which is that connection?
7.
Cuttack. OA number 607 of 2001, whereby the tribunal has directed the petitioners to provide the respondent compassionate appointment in ORO post or grade 0 post,
Grade 4, grade D.
grade D post,
D post.
grade D post. Post op. Next, we have heard learned counsel for the petitioners and learned counsel for the respondent. The facts relevant for the present adjudication are not at all in dispute. The petitioner's father was working as a Mali under Aviation Research Center, Sharbatia, when he met a premature death on 16/9/1990. First off, the mother of the respondent made an application thereafter for her compassionate appointment, of this petitioner, this respondent. She had made an application for appointment of the respondent.
Yes.
Yes.
Respondent on 16/11/1990, the respondent's mother was informed later that the request for compassionate appointment was being processed. On 25/11/1991, 1991, ARC headquarters returned the said application dated 16/11/1990 to the mother of the opposite party, asking her to send the application for compassionate appointment with due recommendation whenever the vacancy arose at ARC Charbatia. So stop. A reminder was sent. Petitioner number 2 thereafter issued a letter to the opposite party that his appointment shall be considered only in case suitable vacancy was available at ARC Charbatia. So stop. It is subsequently a letter was issued by the section officer ARC Charbatia to the respondent to furnish the information by 30/10/1992 positively in the attached statement for further course of action for the purpose of compassionate appointment. So stop. It is the case of the respondent that when 4 number of vacant posts of cooks were available, the opposite party was called to face the interview. He, however, could not be selected. So stops. Subsequently, in the year 1996, the opposite party was called for physical test for consideration of his appointment on compassionate ground to the post of aircraft assistant. So stop. However, because of an interim order passed by the tribunal in a different case, that is MA number 269 of 1996, arising out of OA number 349 of 1995, the recruitment process was stayed. So stop. Later, the said interim order was vacated on 25/1/1999. So stop. As your OA was is 76 of 97.
Yes.
His OA is 76 of 97.
Has to.
Huh?
Has to waiver 761/97.
The respondent approached the Central Administrative Tribunal, Cuttack, by filing OA number 76 of 1997, seeking a direction to consider his case for appointment on compassionate ground against the post of aircraft assistant. First off, the said application was disposed of by the tribunal by an order dated 25/5/2000, asking the opposite party in the test. First off, it is also not in dispute that there was an interim order passed by this court in WPC number 1495 of 1991 against
9, madam.
99 against the against the aforesaid order dated 25/1/1999. First off, resultantly,
I beg pardon, madam. That is OJC, WPC, OJC.
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 You have mentioned OJC number 1495.
Yes, ma'am.
OJC number WPC. OJC.
99.
Then it was OJC. Resultantly, the recruitment process for the said post was state, remained state. Stop. The respondent appears to have approached it appears that the respondent had approached the tribunal by filing MA number 544 of 2000, alleging disobedience of the earlier order of the tribunal. That was the allegation. MA for?
That is filed for to comply the order.
Yes.
Yes.
For alleging disobedience of the order passed by the tribunal on (25/5/2000). Stop. In the meanwhile, the said OJC number 1495 of 1999. In the meanwhile, the said OJC number 1495 of 1999 stood disposed of by an order dated 21/11/2000. Stop. On 30/8/2001, the opposite party was intimated that he could not be selected for the post of aircraft assistant. Stop. Next. Apparently, thus, from the date of death of the petitioner's father in 1990, the respondent could not be given compassionate appointment till 30/8/2001, as he could not be selected for the post of aircraft as he was not found fit for appointment against the post of aircraft assistant. So stop. This led to filing of another original application by the respondent before the tribunal, giving rise to OA number 607 of 2001, seeking quashing of the said communication dated 38/2001. So stop. The tribunal disposed of the said OA number 607 of 2001 by an order dated 15/5/2002. What was the order? Where is that? 15/5/2003. Just a minute.
Annexure 43.
Annexure
Annexure 3, page 43.
Page 42, my lord.
42.
disposed of the. Well, again. 15/5/2002. The tribunal noted in its order that the respondent was not found suitable for the post of aircraft assistant, and thereafter he was given an offer for the post of cook, and again he was not found suitable for the post. So stop. He was also given an offer for employment as Safai Wala / sweeper, but the respondent did not agree for the said offer. So stop. It appears from the said order that the learned additional standing counsel informed the tribunal that the respondent would be given an offer of employment within a period of 1 month. So stop. The respondent also informed the tribunal that he was ready to take an employment if that was suitably offered, that is the post of gardener / mali / peon or any such similar post. So stop. In that background, taking into account the respective stands of the parties before the tribunal disposed of the original application requesting the learned additional standing counsel to exercise his good offices to resolve the problem outside the court as expeditiously as possible. So stop. In 2003, the respondent filed MA number 597 of 2003 before the tribunal, alleging disobedience of the tribunal's order dated 5/5/2002, 15/5/2002. This order was passed in MA.
Yes, ma'am.
The impugned order was passed in MA.
MM 597 of 2003.
Gujarat Tribunal, Central Administrative Tribunal, the Administrative Tribunal Act.
Administrative Tribunal Act. Okay, Rajguru, do you have the Administrative Tribunal Act you have?
So he passed this order. Tribunal. Considering the statements made in MA numbers, MA number so and so by the respondent, disposed of the same in following terms from despite. Despite है second last paragraph of the order. Oh, stop. The said order of the tribunal dated 4/3/2004 is under challenge in the present writ petition. Under which provision MA is filed? MA is filed under which provision? How can you come to the court of the Chief Justice without even the bare acts in your hand? Sure.
Simple to.
The impugned order passed by the tribunal, learned counsel appearing on behalf of the petitioners has argued that while entertaining miscellaneous application filed primarily for implementation of an order of the tribunal, the tribunal could not have issued further directions over and above the directions which were required to be directions issued in OA number so and so, which were required to be implemented. Full stop. He has further submitted that that appointment on compassionate ground cannot be claimed as a matter of right, and with the lapse of time, that is more than 10 years after the date of death of the employee, comma, the respondent's case for appointment on compassionate ground had lost its purpose, since he could sustain himself in the meanwhile. So stop. Next. There is another aspect of the matter which deserves to be taken note of in the present case. The present writ petition was taken up on 24/2/2005 when following interim order was passed. Quote kar do. It was clearly observed in the said order that the opposite party shall be at liberty to file an application for variation of the said interim order after his appearance. You did not file.
Appear after 17 years, notice was issued. After notice was issued after 17 years.
No, notice was issued in 2005.
No, my lord. And the notice is not sufficient. Second timely 2022 notice was issued. And that after I appear before this honorable court.
All right. Notice was directed to be issued on 24/2/2005.
Yes, but that has not been complied by the petitioner. In 2022, fresh notice was issued and I got the issued and appear before this honorable.
The notices were issued on 24/2/2005. It is the case of the respondent that the said order requiring the petitioners to file requisites for issuance of notice was not complied with, and the respondent received notice much later in 2022. Full stop. Next. Learned counsel, appearing on behalf of the respondent, has relied upon the Supreme Court's decisions in case of State of Maharashtra versus Madhuri Maruti Vidhate, reported in 2022 SCC online SC 1327, 2021 volume 2021 SCC online SC 1264 and NC Santosh versus State of Karnataka and others, reported in 2020 volume 7 SCC 617. Full stop. He submits that it was obligatory on the part of the employer to have given the respondent equal opportunity in the matter of grant of compassionate appointment. Full stop. What is his age now?
54.
Any other submission?
Lordship, in their region rapid, they said crystal clear that there is vacancy position, but till that there has not been filled any vacancy position. Two para there in page 4, last 4 line. Are there more deserving candidates having more liability than that of the opposite party applicant? But in the 7 para said that it is also clarified that from the said list, no compensation appointment was offered to any of the candidate.
Where are we reading?
Their region rapid filed by the petitioner.
Which page?
Page 4 of their region rapidity. Para 6, page 4, last 4 lines. Having regard to the parameter prescribed by the government,
Just a minute.
Lordship.
Flag?
Region rapidity filed by the petitioner, page 4, para 6.
Run counsel for the respondent has also drawn the court's attention to the statement made in paragraph 6
The Lordship 6.
of the rejoinder filed on behalf of the petitioners Union of India to the counter affidavit filed on behalf of the respondent that it is an admitted fact that case of various other applicants were pending for giving compassionate appointment, and a list was prepared in which the respondent's name was at serial number 2. So stop. So stop. First off, he said statement in paragraph 7 of scorecard. First off, next. Oh. It is evident from the facts noted above that the respondent's claim for grant of compassionate appointment before the Central Administrative Tribunal in OA number 607 of 2001 was decided with an order that the applicant would be given an offer of employment within a period of 1 month. First off, while disposing of the case, the tribunal had observed that the additional standing counsel should exercise his good offices to resolve the dispute, resolve the problem outside the court as expeditiously as possible. First off, there was no direction issued by the tribunal to appoint the petitioner, the respondent, on compassionate basis. First off, in a proceeding for implementation of the said order filed by the respondent giving rise to MA number
597.
597,
Yes.
Yes, Lords, by 2003.
203.
597 of 2003.
Three. Your Lords.
The tribunal passed the aforesaid order requiring the petitioner to directing the petitioners to provide compassionate employment to the applicant. First off, whether that order would have been passed, but
Lords,
That was annexed now.
it is annexed.
Annexed.
Annex 5,
Yes,
Your
ma'am.
Lordship.
that is MP,
Yes, ma'am.
that's not MA.
MP, Miss Petition. Actually, that the
So
constantly
you are not bringing on correct picture to the court.
Actually, it was MA in tribunal. All cases, minor miscellaneous applications, MA.
That means it is under contempt.
No, my lord, in usual,
MP is under contempt or?
no, my
MP
lord.
is-
Actually, MP was filed before the state administrative tribunal, but MA was filed, usually filed before the central administrative tribunal, MA. It was inadvertently.
We are putting a simple, very simple question.
Yes.
Under which provision of law this application was filed?
So this application is filed by the respondent.
Yes, ma'am.
So you should clarify.
The application was for implementation of the order dated 15/5/2002.
Yes. 55, 15,
15/5/2002,
2002.
my lord.
Hmm.
But provision has not been mentioned. In first para, an application for implementation of the order passed by the land tribunal in way number such and such, disposed on 15/5/2002.
Apparently, the tribunal went beyond the scope of the initial order passed in OA number 607
Yes.
of 2001, dated 15/5/2002. Stop. In our opinion, the order of the tribunal deserves to be interfered with on the said ground alone. Stop. Next. The decisions said ground alone. Section 27 of the Act of the Administrative Tribunal Act confers upon provides for execution of orders of the tribunal, which reads thus. Full stop. We reiterate at this juncture that the tribunal ought not to have gone beyond the terms of the order dated 15/5/2002, passed in OA number 607 of 2001, while exercising power under section 27 of the Act for execution of the said order. Stop. The impugned order deserves to be set aside on this score alone. Stop. Next. The Supreme Court's decisions relied on by learned counsel for the respondent.
Petitioner. Petitioner.
You have relied upon the judgments.
I have.
Petitioner.
Yes.
That issue doesn't fall for consideration. Those
That was
decisions
different.
are relevant when there is an amendment after filing of application or date of death. Those decisions that
The
was
decision-
referred to larger bench, they have said whether what is the appropriate course to follow which rules, whether it is date of application or the date of consideration, the rule existing on that date. So that is not the issue here.
The decisions relied on has that act become functus officio on the issue of the petitioner's respondent's claim for compassionate appointment after having disposed of OA number 607 of 2001 by the said order dated 15/5/2002, and it could not have proceeded further in the said matter except for exercise of power under section 27 of the Act for execution of the order dated 15/5/2002. So stop. Though the decisions relied, we are of the view that the Supreme Court's decisions relied upon by learned counsel for the petitioners are not applicable in the facts and circumstances of the present case, as have been noted above. So stop. The impugned order dated so and so is accordingly set aside, being beyond jurisdiction. So stop. In any event, no purpose will be served by considering the petitioner's respondent's case for compassionate appointment at this juncture, 26 years after the death of the employee, when the respondent has attained the age of 54 years. Stop. Next. With the aforesaid observations, this application is allowed. The order dated so and so passed by the Central Administrative Tribunal in MA number 607 of 2001 is hereby set aside. Yes, public.
Item 2.
Please, Your Lordship. Last occasion, Your Lordship allowed me an opportunity to verify about the status of the SLP. I have got the copies. The SLP stood dismissed mal on 27th February itself.
Listed and it was dismissed. So now I have 2 minutes comply lordship's order. Lordship may grant me some time and will comply with it.
How much?
4 weeks lordship.
4 weeks time is allowed for the contemners to inform this court as to whether this court's order, violation of which has been alleged in the present contempt application, has been complied with or not.
Item 3. Last order, my lords. 13/3/2014 order. And my lords, directed to comply the court's order, my lords. Even though the order has been complied, even though the order has been upheld in the Supreme Court.
Order has
Order of the Honorable Court has been confirmed in the Supreme Court. But till today, my lords, I have been not regularized.
Annex 2 is Supreme Court order.
Yes. Annex 2 is the Supreme Court order, my lords.
The pursuant to lordship direction on 13th of March, the OP number 1 directed the OP number 2, Union Chief to comply with lordship's order in letter and spirit and report compliance in lordship. I had supplied the lordship's copy of that Secretary Water Resources directed him lordship. I had written a letter to the EIC lordship. Till date, he has not responded to my letter whether he has complied it or not.
Today, my lords, I took instruction from my client, my lords, that order has not been complied.
Even secretary's order is also not respected.
Because
Let us see the order first. Which is the order?
My lord, that is annexure 1, my lords, at page 6. The operative portion, my lord, that is at page
11.
11. Just last line, my lords. Last 4 lines. Consequently, the opposite parties are directed to regularize the service of the petitioner and extend all consequential benefits as due and admissible to him in accordance with law within a period of 4 months from the date of production of the certified copy of the order, my lords. Challenging that order, my lord, the state government before the SLP, my lords. Then, my lord, next page at page 12, the SLP was dismissed on 24/2/2023. And in the meantime, my lords, the more than 1 year has been elapsed, but the order has not been complied with. And even though, my lords, last order, even though, my lords, and from December to March, my lords, that is 4 times direction was given to comply the order, they have not complied.
So when you have filed this contempt application,
I have contempt application 2023, my lords.
then we should punish whom?
Because I have communicated the order, my lords.
We should punish whom? Tell us.
That is, my lord, that is the opposite party 1, my lords.
All right. Who is opposite party number 1?
That is, my lord, the secretary, my lord, secretary.
Opposite party
Department
number
of-
1 is additional chief secretary.
Additional chief secretary, the office cannot be punished.
That is not Anu Garg, my lord, that I have made in the party, my lords.
Who?
Anu Garg, IS. In content application.
Yes, ask all of them to be present.
yes, pursuant to lordship direction 13th of March, lordship directed me to comply the order by the lordship.
No, ask all of them to be present online.
Actually, who is to regulate this?
No, so in fact, it should be the executive engineer. So EIC has to implement the order directing the executive engineer comply with the same because he was a class 4 employee.
No, class 3.
3.
The appointing authority is the
Executive engineer.
executive engineer.
But the
Secretary directed.
directed the EIC, he should have taken care of. In the meantime, 7 days, he should have done it.
He is executive engineer in charge.
No, engineer in chief,
Engineer in charge.
head of that department, engineer chief, he should have complied because the secretary pursuant to lordship direction that gave him an instruction, apply the honorable court's order and report compliance before lordship. Right,
In the meantime, seek instructions, and you can tell them
right.
that we shall be taking extreme steps in
Right,
such matter.
No.
All right?
Yes.
At 4, we will take up the matter again.
Yes, no.
Let the executive engineer join.
Join online.
Yes, no.
The matter shall again be taken up at 4 p.m. when which engineer, chief engineer,
Engineer in chief.
when Basant Kumar Raut, chief engineer, minor irrigation, Odisha, shall be required to join the proceedings online for the purpose of framing of charge of deliberate violation of this court's order amounting to contempt of court against him. Full stop. Yes. That the opposite party number 2 has not complied with this court's order despite a request made by the
Open number 1.
opposite party number 1,
Additional Chief Secretary,
Additional chief.
the additional chief secretary,
Department of Water.
Water.
Resources.
Department of Water Resources, Odisha. First off, let opposite party number 1 also join the proceeding at 4 p.m.
Let her also know.
Yes,
Let
no.
her also know that her orders are not carried out by
Carried out.
subordinates.
Yes, no.
Item 4.
May I please your lordship, my lord?
Yes.
I have filed a writ appeal, my lord, challenging the order dated 22/12/2023, passed by the Honorable Single Judge, my lord. Annexure 15, page 36, my lord, improved order, my lord. I challenge the improved order.
Annexure?
Annexure 15, my lord, page 36, my lord.
Yes.
And I challenge the order, my lord, on the ground that, my lord, the improved order has been passed on the basis of the order dated 3/7/2017, passed in WPC number 10935 of 2017, filed by the respondent number 5, which has been recalled in the review petition. That has not been taken into consideration by the Honorable Single Judge while disposal of the writ petition, my lord. My lord, fact of the case is that, my lord, the appellant was appointed as the Anganwadi helper of Kiarapur 2 Anganwadi Center by the CDPO Soro in the district of Baleshwar, my lord. While the appellant was
Just a minute. What is your submission?
the improved order has been passed on the basis of the order dated 3/7/2017, man.
3/7/2017.
Passed in WPC number 10935 of 2017, which has been recalled in review petition. Review petition number 287 of 2017.
287 of 2017.
Mine.
What is the order of recall?
Recall 3/7/2017 order is recalled.
3/7/2017 order
Is recalled.
was passed in WPC number 10935 of 2017
17, my lord.
by this petitioner.
Filed by the respondent number 5.
Respondent number 5.
Who is the another candidate, my lord?
That was under review.
My lord.
Review 287 of 2017.
My lord. My place, my lord.
You are representing Mamata Behra.
My lord, Mamata Behra.
So which order has been recalled?
Order dated 3/7/2017.
Has been recalled.
Recalled.
By which order?
My lord, kindly have a glance.
By the order dated
Annexure 14, page 32.
24/7/2018, that is in review petition number 287 of 2017, that is at page 34.
My lord, Annexure 14, page 32.
Yes, yes, order portion is 34.
My lord, order person is 34.
And you are challenging which order?
You are challenging, my lord, after recall of the order, when the CDPO did not take any step, my lord. I filed a writ application challenging to my termination order. In view of the order, the CDPO terminated me from my service, my lord. And terminated me from my service and also convening a fresh Mahila Sabha in which the respondent number 5 was selected and appointment order was given to respondent number 5, my lord. That order has been recalled in the review petition. After recall of the
You
order,
are challenging which order?
we are challenging, my lord, Annexure 11, my lord.
You are challenging Annexure 11.
My lord.
You
Termination
are
order.
challenging which order of the learned single judge?
Annexure 15, my lord.
Annexure 15.
15, page 36.
All right. So Annexure 15 has been passed relying on
On the basis of the order dated 3/7/2017.
2017.
My lord.
How do you say that?
My lord, kindly have a glance. Operate page. Sorry. Page 48, my lord.
So it does not appear from this.
My lord.
From Annexure 15, it is not clear.
Man, page 48, para 25, my lord.
Page 48.
My lord, para
All right.
25, my lord. Srimati Suputi Puran, the present Anganwadi helper of Kiarapur 2 Anganwadi Center, had filed a WPC number 10935 of 2017 before this court, which was disposed of for 3/7/2017, with a direction to the CDPO Soro to convene the fresh Mahila Sabha within a period of 3 months. Srimati Puhana had further filed a CONTIS number 1 so before this court with a prayer to for yearly implementation of the kind orders dated 3/7/2017 passed by the Orissa High Court, Kotak in WPC number 10935/2017. And next one, 26 para. Accordingly, in order to convene the fresh Mahila Sabha for selection of Anganwadi helper at Tiarapur 2 Anganwadi Center and to implement the order dated 3/7/2017 passed by this court in WPC number 10935 of 2017, the CDPO Soro had published notification number so and so dated 13/3/2018. Accordingly, both Mamata Bhara and Supradeep Puhan and another candidate named Srimati Padmavati Bolo had applied for the post of Anganwadi helper in Kiarapur 2 Anganwadi Center. The Mahila Sabha was conducted at Kiarapur EP School on 23/3/2018 in presence of.
And where is the recall order?
That has been recalled, man.
Where is that?
Recall minor Annexure 14.
Page 30.
Annexure 14 minor.
14.
14, page 32, relevant page 34, relevant page, man. Man, operative portion para 4, man. Annexure 1 to the review application shows that the petitioner was appointed as Anganwadi helper in Kiarapur 2 Anganwadi Center on 12/8/2015. The said fact has been suppressed. The petitioner is guilty of suppression.
To that case?
My lord,
What happened to that case? 10935 of 2007?
my lord, both the case was taken up for,
What is the present stage? The order has been recalled. The writ petition has been directed to be restored to its original file. So what happened to that writ petition?
my lord, my writ petition and that petition both.
Mr.
My,
1081 was not entertained.
my lord,
A common order was passed.
my lord.
One was not entertained.
My lord,
In 10935,
my lord,
there is an order.
my lord,
Now in 2018,
my lord,
that order was recalled.
my lord,
Qua 10935, right?
my lord.
So now you have come to say in this writ appeal,
Mm.
filing in 2024,
My lord.
you are challenging 2018 order,
No, my lord, 2023,
23.
22/12 is, passed by the Honorable Single Judge, my lord. 22/12/2023.
Oh, that is fresh order passed.
My lord,
That is different. Then you have to issue. What happened to that writ petition that has been restored to original file 10935 of 2017?
my lord, after review,
That is disposed of, my lord.
both the petition was disposed of at the same time.
38, page 38, sir.
Mr. Counsel, that writ petition was disposed of by an order.
My lord,
That order was subsequently recalled
my lord,
with her direction that that writ application stands restored to original file.
my lord.
What happened to that writ petition after it was restored to original file? That is?
Again, it is disposed of.
You take up for-
Page 41.
In 2023.
So now both the petitions are.
He is referring to 2018 order, saying that both were recalled, now fresh order has been found. He is challenging this. No.
No, but you
On-
can
on
challenge
which-
this, but not on that ground.
My lord,
See, recall has gone now. Recall has no value. It has lost its sanctity now because in 2023, in both the writ applications, separate orders are passed.
after a recall of the order, when the CDPO did not take any step, after recall of, on the basis of the order dated 3/7/2017.
Mr.
After
Please,
recall.
please try to appreciate.
My lord,
You are getting all of us confused.
my lord,
You created an impression
my lord,
that the learned single judge, while deciding the case,
my lord,
did not take into account the fact that the order dated 3/7/2017 was recalled.
my lord,
It was because 3/7/2017 order was recalled that the writ petition was placed again for consideration.
my lord.
Then
3/7/2017 order is at 25, page 25. He has not placed that. That's why he got confused. The sequence you have not placed. At page 25, 2017 order was there. That 2017 order was recalled in 2018. Both the cases were placed before the learned single judge
Right.
for fresh consideration.
My lord,
And they, by virtue of a common order, in 2023,
my lord,
learned single judge has passed an order.
my lord,
That order you are challenging now here.
my lord. My lord,
The sequence.
my lord, the appellant, my lord, fact of the case is that, my lord, the appellant who was appointed as an honorary helper.
fact of the case is that we should not rely on the oral submissions which you make based on the, while referring to the records. We should see the records ourselves. Yes, any other ground to assail?
Man, while the appellant was continuing as an honorary helper of TR2 Honorary Center, the
Mr.
respondent,
Counsel, you should be careful that we are in writ appeal,
my lord,
not in ordinary appeal. We are not appellate authorities.
my lord,
You have to show the infirmity or perversity in the order passed by the learned single judge, right?
My lord.
So to that extent, you confine your argument.
I pray, my lord, kindly next week, my lord,
No,
fully prepared, my
sorry,
lord.
sorry. We are coming within 5 minutes. You can prepare, if you can prepare yourself. It's all right. Yes.
My lord, my lord. My lord, the applicant was appointed as an Anganwadi helper of Kiarapur 2 Anganwadi Center. While the applicant was continuing as an Anganwadi helper, the respondent filed the writ petition number 1051093 of 2017 before this honorable court. Man, without challenging of my appointment or without impleading the party in her petition, by suppressing the facts, he filed a writ application before this honorable court, praying therein a direction may be issued to convene the Mahila Sabha and select the Anganwadi helper of Kiarapur 2 Anganwadi Center, my lord. While the applicant was continuing, my lord. My lord, kindly have a glance, Annex 8, page 25. Annex 8, page 25, my lord. The writ petition was disposed of on 3/7/2017.
That is not existing, sir, after subsequent order.
My humble submission before last week, in the order dated 3/7/2017,
That is already recalled. You have not challenged that recall order. So how are you placing this?
my lord,
See,
my
3/7/2017 order no
My-
more exists by virtue of recall in 2018.
my lord,
Which order you have not challenged, that has attained finality thereafter. Fresh,
Sir, the order was recalled on your application. You had filed the,
Returns it was recorded. At his.
at his instance, that was recalled.
recall, my-
you filed an application.
Then 2017 order does not exist now. He is placing this.
So my humble submission equals to the CDPO Soro on the basis of the order dated 3/7/2017 terminate the service of the petition. My humble submission, the order dated in the order dated 3/7/2017 nowhere stated to honorable court not directed.
All right.
My lord.
3/7/2017 order has died.
My-
And has been buried.
My lord.
Now make your submission. There is no order 3/7/2017.
After recall of the order, my termination order is not sustainable in the eye of law.
That is different.
And also appointment of opposite number 5 are not sustainable in the eye of law.
Is it your case
My lord.
that even after recall of 2017 order
My lord.
pursuant at your instance
My lord.
in review in 2018,
My lord.
that even though it was recalled, the CDPO has complied 2017 and terminated you?
My lord.
That is your case.
My lord.
Then you have filed this
2181
yes.
of 2019, my lord.
So that is the subject matter before the learned single judge in 2023 order.
But even that has been considered.
He has considered at para 7.
My lord.
Para 7 of the judgment of the learned single judge, which is under challenge here now. 42, page 42.
My lord. And sir, 15, I am challenging in this case, ma'am.
Yes. Page 42. You come to page 42.
42. 42.
Para 7.
My lord. After receipt of the aforesaid order from the petitioner, the CDPO Soro Opinion 4, in pursuance of the order dated 13/11/2015, passed by the Sub-Collector Balesar by letter dated 25/2/2017, directed the petitioner to resume her duties as Anganwadi helper in Kiarapur 2 Anganwadi Center and submit her joining report as well as show goes before the undersigned for acceptance My lord, para 7 is the my lord. Earlier, the petitioner was terminated from her service. Earlier, my lord, in the year of 2015. Against that termination order, I had approached before this honorable court. This honorable in the year of 2015, the honorable court was pleased to quash the termination order and direct the CDPO Soro to proceed afresh by providing an opportunity of hearing to the petitioner. Pursuant to order of the honorable court in the year of 2015, they again resumed to my service by order dated 25 to 2007. As per the order dated 25 to 2017, I joined in my service. After joining in my service, the respondent filed a writ petition without challenging of my appointment and without implementing the party in her writ petition. Filed a writ petition, place before this honorable court, a direction may be issued to convene the Mahila Sabha and select the honorary court. While the applicant was continued.
That is bearing number?
Writ petition number in the annexure 4. Annexure 4, my lord. Annexure 4, my lord, page 18. Documentation number 157.
That is of Mamata Behra.
Mamata Behra.
That is 2181.
No, my lord. Annexure 4, page 18, earlier 2015.
Then what is 2181 of 2019 then?
2181 I challenged my termination order and also appointment of opinion order 5 because on the basis of the order dated 3/7/2017, I have terminated. That order already recalled. After recall, no termination is sustainable in the eye of law, my lord.
Can you assist?
Yes, my lord. Lordship, I see para 9 of that order, my lord. The lordship can find my lord's query. The two dates are important, my lord. The lordship may see para 9, page 43. This petition was terminated on 12/3/2018. The review order was passed on 24/7/2018. Review order was passed on 24/7/2018. Prior to that, he was terminated. It was his case. After the review order, he was not reinstated. So he filed a case that is of 2019. Both the matters were, he filed a case, lordship can, that is 2181 of 2019. Perhaps that was the case for his reinstatement. Both the cases were taken up together. This case
10935
10935 and 2181 of 2019.
10935 is by another person.
By who had the respondent number 5 here. Both the matters were taken up. Honorable single judge direct. Both them on the basis of that earlier order directed to convene that Mahila Sabha and on the basis of that Mahila Sabha.
Oh.
That is the case.
Without considering your
That review order
propriety of his termination.
and the subsequent conducting of that Mahila Sabha in pursuant to earlier order of this honorable court, which has been recalled, that has not been perhaps taken into account. Every aspect has been taken into account. All these facts have been taken. No.
Mr. Khuntia, before review order being passed,
Madam,
Mahila Sabha
Yes.
pursuant to that
earlier order.
earlier order was convened.
Yes. The date is
So
13/3.
basing on that, now
Honorable Single Judge had directed.
My lord,
What is wrong in the order?
my lord, wrong, my lord. Double piece number 10935 of 2017 is not maintainable at law, my lord. The
Why?
petition was filed without challenging the appointment of the appellant or without implementing the appellant as party in her petition.
Sir, that was not, earlier it was wrongly filed. Now, pursuant to whatever order passed in that case, a decision was taken. Which decision you challenged? You challenged the order passed in the writ petition 109735, whatever is that. 10935.
Right.
You challenged that order by filing a review application.
Right.
Your review application was allowed.
Right.
The writ petition got stored. You filed your writ petition
My,
against the termination
my,
2181.
my,
Both the writ petitions were heard.
my.
Now, every aspect has been taken into account, your submission, the other party's submission, and thereafter the decision has been taken. What is wrong in that?
Well, the writ petition is not maintainable, my lord.
My God.
10935/2017 is not maintainable at all, my lord.
Why?
But while the applicant was continuing as ordinary helper, he filed the writ application without challenging the appointment of petitioner.
Therefore, the order was reviewed, Mr. Counsel. There, because the writ petition was, you were not pleaded, therefore, the order was recalled.
My lord.
That was the reason.
Right.
So that was not maintainable, you are right. In your absence, the order could not have been filed, you are right.
My lord.
And therefore, that order was recalled. Why are you repeating that?
Well, in the order dated 3/7/2017, the Honorable Court not directed the CTPO order to terminate the service of the petitioner or cancel the Mahila Sabha. By misinterpreting the order dated 3/7/2017, the CTPO Soro cancelled my Mahila Sabha and terminate me from my service, my lord.
Oh, please be kind to us. 3/7/2017 order is not there. So the writ petition was heard afresh. This writ petition 10935 was heard afresh by learned single judge. CWJC 2181 was heard afresh, which was filed by you. So both the writ petitions were heard. The entire gamut of the case was taken into account and thereafter the order was passed. You are taking advantage of your own. I would not say that. Yes.
Item 5.
May it please your lordship. My lord, here the petitioner challenges the order under Annexure 7 in the writ appeal at
What is BLF here? Yes, Section 7.
yes, Annexure 7, well. That's the impugned order wherein the learned single judge has allowed the evidence to be adduced which are beyond pleadings, and as well it militates against the order of this honorable court in a previous writ application. May I read the brief facts I'm taking your lordships to? Brief facts that the appellant herein is the elected Sarpanch, and her election was called in question by the respondent number 1. The respondent said that she is disqualified in view of disqualification under Panchayat Act section 25V of having more than 3 children. Now, your lordship, the crucial thing is the election petition itself, which is the root cause of all this. Your lordship may see at
So this relates to election to which post?
Sarpanch.
Sarpanch.
My lord.
You were elected.
Yes, my lord.
After that, what happened?
Respondent challenged my election on the ground that I am disqualified under section 25V of
Where?
that is annexure
No, where did he challenge?
before the election tribunal. Election tribunal comes civil judge junior division Jajpur.
How the matter has traveled to this court?
This, my lord, evidence was sought to be adduced in that petition which were beyond the pleadings of the election petition.
Then,
So I filed a writ application.
hey, what is this?
I filed a writ application in view of the and
Why not?
that also, my lord, the order which is impugned before your lordship passed by this honorable court.
Oh,
Wherein,
election, let that be decided.
my lord, my written statement was also denied to be
Let that be
amended.
decided. You can challenge that. Not in the present proceeding.
My lord, may kindly see the order just
Impossible, impossible. You are asking something which is impossible.
just for a moment, if for my satisfaction, my lord. Only
We are not sitting here for. your-
sorry, my lord, for the
Mr. Counsel.
sorry, my lord.
Yes.
In fact, the order which has been passed in the earlier writ petition was an order where I had challenged that in view of the later development, I may be allowed to amend my written objection.
Sorry, we cannot. This court cannot.
That has been but it had been allowed
No, no.
in the view that
Sorry, sir.
Only one order of your lordship, single judge order, my lord.
Sorry.
That my lord, here it is stated that there shall be no pleadings beyond there shall be no evidence beyond the pleadings. And the court has been
We should
directed.
decide the election petition.
No, my lord, that portion only. That is before your lordship.
Sorry, this is abuse. The appellant in the present intra-court appeal has questioned the correctness of an order dated 28/2/2023 passed by a single judge in WPC number 2767 of 2023, whereby the petitioner's writ application has been dismissed. Next. Facts of the case are that the petitioner was elected Sarpanch of which panchayat?
It is, my lord, Ratnagiri Gram Panchayat,
Of Ratnagiri Gram Panchayat,
Wadi Block, Jajpur.
which became subject matter of challenge in an election petition while election miscellaneous case number 10 of 2022 in the court of London Civil Judge cum Election Tribunal, Jajpur. Stop. The appellant filed a writ petition before this court at the stage of adducing subject matter of challenge in election filed by opposite party number 1.
Yes, my lord, the writ petition has been filed by the present appellant.
No,
The election petition by respondent, yes.
by the respondents. Stop. क्या लिखा रहता है? At the stage of the evidence being adduced sentence record. When the evidence was being adduced, the respondent is said to have filed a petition on 16/5/2023 seeking examination of 3 more witnesses and adduce 4 documents relating to birth of 3rd child of the appellant.
Well,
stop. The order has been passed.
Yes. That was impugned before this law.
The said petition dated 16/5/2023 was allowed.
Yes.
Was allowed. Stop. By an order dated
That was order dated. My lord. 16th May, it was 9/8/2023.
9, which you challenged in the writ petition
Yes, my lord. Annexure 6, 9/8.
by the London Civil Judge cum Election Tribunal. Stop. The said order was sought to be challenged by the appellant in the aforesaid WPC number 26767 of 2023, which has been dismissed by the London Single Judge by the impugned order dated 2024. Stop. Next. Learned counsel appearing on behalf of the appellant has attempted to convince this court that the election tribunal ought not to have allowed the petition for adducement of evidence beyond pleadings. And therefore, the learned single judge ought to have interfered with the said order in exercise of power under Article 226 of the Constitution of India. Stop. Next, we do not find any legal infirmity in the impugned order passed by the learned single judge. Stop. We are of the view that the writ petition filed by the petitioner was itself not maintainable under Article 226 of the Constitution of India against the order passed by the election tribunal in the facts and circumstances of the case, questioning the putting to challenge the election of the appellant to the post of Sarpanch under the provisions of, what is that act? Panchayat Raj?
Orissa Panchayat Act.
Odisha Panchayat.
Gram Panchayat Act.
Odisha Gram Panchayat Act 2000.
1964.
Read with must be election rules. Read with
Election rules. Orissa Gram Panchayat election rules 1965.
read with this appeal has no merit and is accordingly dismissed.
Item
With
6.
permission of your lordship, one more submission that my written statement in consonants be allowed.
No, we should not.
That was rejected in fact.
Maybe.
Item 6.
May I please, Your Lordship? The one common order passed by the Honorable Single Judge in two writ applications, one writ application filed by the appellant and another writ application filed by the respondent number 5. That order is under challenge before in this appeal, my lord. On the ground that the single judge has not whispered a single sentence regarding the case of the appellant in the impugned judgment. The fact of the case is like this. On the basis of advertisement, appellant and respondent number 5 and other two candidates applied for the post of Anganwadi helper. And when Mahila Sabha was not held due to disturbance created by the villagers, the selection committee selected the appellant for the post of Anganwadi helper in Chakuda Anganwadi Center. And thereafter, the respondent number 5 made an allegation to the sub-collector against me, against the appellant, and subsequently filed a writ application before this Honorable Court without impleading this appellant as party. And this Honorable Court, that is WPC number 27,945 of 2020. And this Honorable Court directed the sub-collector to consider the representation of the respondent number 5 in accordance with law. That order is reflected in my appeal memo. And subsequently, the sub-collector, before the sub-collector, this appellant was not made as party. And even if I am continuing in the post of Anganwadi helper, as per the appointment order, engagement order issued by the CDPO, I was not made party before the sub-collector, and behind my back, without hearing me, without giving any opportunity of hearing to me, sub-collector passed order to disengage me from the post of Anganwadi helper within a period of 7 days. That order was challenged
by this appellant before this honorable court in WPC number 13,448 of 2022. That order of the sub-collector was challenged before this honorable court in WPC number 13,448 of 2022.
Such disputes, Mr. Counsel, should be decided finally at some other level. Otherwise, it's very difficult for the High Court to function even with these such type of cases. Disputed questions of facts
Yes.
coming to the court. Do you have any appellate authority or?
Yes, press advertisement. That is the subject matter challenge, and your lordship has held that there is no illegality in issuing the direction to issue press advertisement.
What
And thereafter, after sub-collector, there is no.
So that this was under challenge after my lord's direction. What is the development? I don't know, well, because this has come for the first time.
No. My lord wants to know whether any forum available
There is
after
no forum.
after appeal order is being passed
No,
directly
no,
to the writ.
direct.
the
Yes.
learned
Your lordship kindly have a glance in page 47. Only CDPO was the party. The appellant, when the appellant was continuing in the post of Anganwadi helper, his right has been accrued and she is the necessary party. Without impeding her party behind her back, how this order will be passed to remove her within a period of 7 days? At 47, last paragraph 49, only basing on the affirmance made by the respondent number 5, this order was passed. It is clear violation of the principle of natural justice.
Now we can hear you.
Pardon my.
We are giving you that opportunity of hearing. What is wrong in that order?
In that order, impugned order, I filed writ
Now,
application.
just consider a circumstance that we are sub-collector and we are considering the appeal, you are a party. Now tell us what is wrong in that. Tell us whether we as sub-collectors could have taken the same decision in your presence which has been taken by the sub-collector or not.
My submission is before the sub-collector, the order was passed behind and back. Anyhow,
Okay.
anyhow.
Now we are giving that. opportunity to
Yes,
you.
my lord. Before the sub-collector, in 2 occasions, the report of the CDPO filed before the sub-collector, kindly have a glance.
Please come to the order of the sub-collector. Where is that?
Pardon?
Where is the order of the sub-collector?
At page 47. And the report is at page 45. The report of the CDPO.
Just a minute. What is your name?
Suchitra Rao, Suchitra Behra.
Suchitra Behra.
Yes, ma'am. alias Rao.
So which order was passed by the sub-collector?
Order in SSW miscase number 1 of 2021 at page 47.
That was filed by you.
That was filed by respondent number 5, my lord. I was not made as party.
Your name is there, Sanju Lata Behra.
He has mentioned, but in the cost title, mine
Sanju Lata Behra, not Suchitra Behra.
respondent number 5 filed.
Notes down the name of Behra being appointed.
Now, please come to page A48.
48, man.
Yes, where are the guidelines?
Guideline is on the basis of Mohila Sabha, the
Where is the guideline?
guideline.
You remember everything and we don't know anything. So this is the huge gap.
Guideline.
Please don't come to the court without books.
Guideline are not.
Come to paragraph 48, page 48.
48. This report of CDPO Basta.
It has come to the notice of this court.
It has come to the notice of this court during hearing of this case that the advertisement of CDPO Basta was made on 31st 10 2016 for selection of Anganwadi helper in Chakuda 1 Anganwadi Center. The CDPO Basta convened Mohila Sabha on 23/3/2017 and again on 18/9/2019 after lapse of 2.5 years. She had convened selection committee
So
meeting.
these facts are admitted.
Because first the Mohila Sabha was convened on 23/3/2017. It was due to the disturbances created by the villagers.
Whatever, whether these facts are correct or not.
Yes, these facts are correct. And why it was called 2 occasions, Mohila Sabha was called for 2 occasions, that has been reflected in the report of the CDPO at page 45. He said that the Mohila Sabha was convened at page 45 on 23/3/2017 to fill up the above post, but some unsocial people of Chakuda village created disturbances and snatched the voting papers, for which meeting was postponed. Again, date was fixed to 18/9/2019 to convene Mohila Sabha, but same result was held. Though huge number of Mohila members were
We
attended.
cannot
but the
decide such appeals, mister, on the basis of your general knowledge. And do you have copy?
Manual.
There is a book of Sangram Das.
Compilation.
Yes, compilation. If your lordship give me some time, I can produce that.
Please, this is the court's request to all members of the bar.
Sorry.
Please don't argue any matter if you don't have the Bear Act or the guidelines or the books with you.
After recess.
As requested on behalf of the appellant.
Tomorrow.
This matter on 8 weeks.
8 weeks.
Item 7.
My lord, tomorrow.
Sorry,
She will be discouraged for that reason. Tomorrow. Sorry, my lord. Very sorry.
8
Actually,
weeks.
sorry. Actually, sorry. Tomorrow, my lord. I will bring the all books and necessary paper. Tomorrow, my lord. I pray.
Tomorrow. Next week.
And next week. Next week, Monday, man.
8 weeks.
My lord, in item number 7, and also directed the state to file counter affidavit. We have received the otherwise comments and all instructions. Only 1 week time may be granted. We'll file it in shape of affidavit. We'll file it next week.
Yes,
Your Lordship queried as to why the sale deeds are going on illegally.
Everything will be addressed in our contract.
as requested on behalf
Only
of
10
the
days time.
state. 2 weeks further time is allowed to file counter affidavit.
Item 8.
May I please, your lordship? Lordship, the petitioners are the local inhabitants, and the public grievance is raised by this representative petition. Lordship, the opposite party number 7, who is illegally occupies the forest land which is belongs to the Ravana Reserve forest area, and due to the opposite party number 7, the act of the opposite party that is drastically affected the local evidence that he is creating the affected the mobility of the local person as well as the environment to make.
So did you approach the Pollution Control Board?
No.
So we are Pollution Control Board, we are NGT, we are.
Lordship, no, my lord.
Then approach. Learned counsel for the petitioner after some argument seeks permission to withdraw this writ application with the liberty to approach appropriate forum in accordance with law.
Lordship, kindly, may I humbly pray, kindly come to annex number 4, my lord. This is the very right, but this in the meantime, the petitioners are already approached the different authority of this locality, like the different authorities, collector as well as the Tahsildar and Forest Reserve authority, all the persons, my lord. And this is the report of the RI, that is
Pollution Control Board, hai? Pollution Control Board must be having. Or National Control. Do you have any idea whether any other forum has jurisdiction to entertain such grievances?
Yes, ma'am. Forest Department.
Forest Department. Under which provision?
Lord, allegation of encroachment of forest land, and they are also damaging the forest products. That is their view. So they can approach the NGT. That is also cognizable by
NGT. There must be some body before NGT. Think Pollution Control Board.
Then
State Pollution Control
Board. Lordship remembers, your lordship has rendered a judgment that in case of encroachment, they can approve.
That is different.
Yes.
That is different.
This is a case of encroachment.
It relates to environment. It relates to forest.
That is why environment issue is there. So NGT is the.
Mister, you just file writ applications without examining the legal provisions.
Sorry, madam. Next time I will be.
So there has been encroachment?
Yes, madam.
Of the forest land?
Yes, madam.
Which provision of law has been violated? Why will you not know this?
Lordship, kindly give me some time.
The public interest litigation is not an ordinary thing.
Yes, ma'am. Lordship, kindly further allow me some time. I will keep present in better way.
Forest Act है NGT अपनी है Forest Act
It's 30. Yes.
You will have to denounce something. Please examine tomorrow. Oh, 1 week. Thursday.
My lord, for more.
Thursday. And in the meanwhile, please examine.
My lord, may I suggest one thing? He has annexed a letter, your lordship may see page 35, that the forest authority should notice to the opposite.
We
party
will
to-
not take into account any fact.
Yes.
We will examine law and if required, we will lay down guidelines. All right. So that such matters may not come directly to the High Court. They should approach the statutory authorities who are duty bound to look into such aspects. Otherwise, the National Green Tribunal Act is there, the Indian Forest Act, forest rights are there. So those provisions should be invoked. Why a person should come to the High Court unless there are compelling reasons? It's
You
not
may
that we
have-
cannot entertain.
You may have some provisions in the Forest Rights Act, 2006.
Mayor, Peer,
May-
Lordship, there is the theta, already the forest range officer was,
Please don't address on facts unless you don't have any idea about law.
So-
Unfortunately, we also don't have. Yes.
But this is the facts in record. that-
Let us see. There is no record.
Obligement.
Item 9.
May I please, my lords. In this application, my lords, petitioner has challenged, my lords, the constitutional validity of section 14 of the CGS Act, my lords. 16(4) of the CGS Act, and also two statutory notifications purportedly.
That has been upheld.
I know, my lord, your lordship judgment in Patna High Court, Govinda construction, my lords. Now, of course, after your lordship passed the judgment, matter went in appeal before the Honorable Apex Court, and the Honorable Apex Court gave the order. Was pleased to issue notice on both pillars, SLP as well as IA.
Maybe because that's a very important question of law involved.
Exactly, my lord. And not only my partner, 3-4 high courts have also, my lords, has concurred with your lordships
Yes, Calcutta, I
Yes,
think,
yes.
Bombay.
Except Madras High Court. Madras High Court has relegated the matter back to the authority, saying that because many aspects are there, because they have examined in detail regarding the notifications, the various provisions, and those provisions says, Millards, your lordship persuaded by Millards one factor, saying that so far as 16.4 is concerned, whether Millards the non-obstante provision overruled 16.4, and your lordship said that section 16.1 is eligibility and section 16.2 onwards, 2 to 5, those are all Millards conditions which need to be satisfied so as to have the benefit of Millards concession. And also question arose whether grant of this ITC concession is a matter of concession or it's a vested right. My lord said vested right it can be, but only when the conditions are satisfied, as enshrined in subclause 2 to 5 Millards. So the only question left is Millards. There are in fact certain other provisions Millards.
So let this matter also go to, let this be decided. Let there be decision of Odisha. Let there be a decision of Odisha High Court also.
Exactly.
For the Supreme Court to decide.
Very correct, very correct. And Millards, the second issue is, your lordship have also Millards addressed that notification in one more case which I was addressing the other day. Your lordship has passed some interim order directing that proceeding not to be finalized without leave of your lordship Millards. Millards, that 70 is the outer limit, my lords, we can't remember. 168A says that conditions of force majeure must be satisfied. And there are two notifications. Earlier notifications was there somehow near neighborhood of that force majeure, COVID. But that 5/7/2022, which was issued by the central government, claiming to be on the advice of council after COVID was over and without mentioning any reason. Earlier notification that says because of COVID-19. And 5/7/2022, the only thing that 168 says on the conditions of force majeure, unless war is there, epidemic, unless these are there, you can't do that as a matter of course, because that has an effect of subverting other correlated provisions. As my lords know, let me not elaborate much. Section 73 basis of outer limit is 3 years from the end of the due date for filing annual return under 44 Millards. 44 stood extended till 7/2/2020. That means if your lordship adds 3 years to that date, so maximum 7310 order can be passed not beyond 7/2/2023 Millards. But here, we're giving a go by to all that. If at all you want to provision, you have to first. That is why Allahabad High Court Millards. That is yes, that's pending. Because one of the High Courts I will say lordship that said that let the council take specific instruction on what are the reasons that pursuant to the council recommending to issue this notification expanding the statutory outer limit. Specific question your lordship asked and the counter affidavit yet to be filed in that petition Millards. That's of course in other High Court. So my humble summation for lordship is here Millards. There is no force majeure condition. And these two notifications, 5/7/2022, and not only government stopped there, it again moved ahead by issuing another notification, that is 31/3/23 by Annexure 11, extending the date for completing adjudication, that is outer limit, to 31/12/23. There is no such situation that it can't go on extending from time to time. And thereby paralyzing operation of all correlated problems, provisions, other related provisions, Millards. So that is why in all these matters, and these matters are ordered.
How many cases are there?
Exactly. And these matters.
How many?
Millards, this is one matter, other matter for lordship, and some other matters are also, I believe, because now court number 3, wherever statute is challenged, those are, because those are brought before your lordship. Yes, the assignment which is now
so here you have crossed the outer limit.
Outer limit. No, I have not crossed. The department, while passing the order, they have crossed the outer limit, my lords.
Basing on the notification.
Only for Millards 17/18. That is for 17/18 Millards. And so far the 18/19, 19/20 is concerned, that pertains to 16/4 Millards. It's a consolidation order, Millards, that cannot be severed. So that is how I stand, Millards.
Contrary to section 168.
Correct. 168A minus. And that matter is examined by 4 high courts, other high courts, Millards. And all high courts, Millards, they have entertained, they have directed passing interim order, either in the so-called stays by directing not to pass final order. And in our high court also, in global NGM, directing recovery also till the next date. That is how matter stands at various high courts. Our global engine, I will one more judgment of my lord.
You are representing the Union of India.
No, Lord. I am representing Lord Commissioner, Lord.
Union of India is necessary party, my lords. Because of 168A, I am challenging Union of India.
But all the shame, Lord, the order has already been passed, Lord. If you are not see addition three,
No.
order has been passed, Lord. In the meantime, he has not challenged the so-called stating that the notice itself is not in conformity with the notification under section 168A. So now it stays, Lord, he has already been passed, that has been considered in the order itself, no?
It's an adjudication order under
Yes, yes.
168A. Amending and extending 7310 is in respect of adjudication order, not in respect of notice.
Yes, that notice has been issued to be adjudicated the process.
7310 says the order required to be passed under section 739. Now the date is extended till the date invoking 168A, which cannot be. That is what a different high court subset.
I'm not going to put that.
This honorable court's order.
This is the order which has been passed in other cases.
By your lordship, lordship.
Yes.
Mr. Sapti,
Yes,
With the same order, can we pass?
this will not be, has been passed.
we have kept it for examining
Yes,
the
yes.
issue.
Yes. But only minute so far as the notification.
No, only difference is, let's see, this case, your lordship have said no final adjudication order shall pass without leave of the court, but here adjudication order is passed. So therefore, your lordship have to no coercive action only that to that extent.
And here lordship kindly.
Against order, white annexure, 5 minutes. 5 and 6.
And when are they coming, these writ petitions? Date is not mentioned.
But it's,
Oh, 5/3/2023.
Lordship, on the said date, counter affidavit was filed by the department. So we had sought time to file rejoinder. And Union of India has taken time to file the counter affidavit as well.
So when is that matter coming?
No date is fixed as of now.
No, it is impossible. Date must have been fixed. Have you seen the order?
Yes, Your Lordship.
In the order, no date is mentioned.
It's 2 weeks after.
2 weeks after.
Was passed by this bench, this bench.
Your Lordship.
All right.
By the coordinate bench.
No, but I'm referring to this order, WPC number 3703 of 2024 was subsequently placed before the bench presided by Honorable Justice Sarangi.
Yes, Your Lordship. On 5th of March.
He emailed it.
Lordship only is only confined to the state notification, not 16.4. When he has challenged 3, one is the adjudication order, one is the filing challenge by 16.4, and next one the notification. This order has been passed only confined to the notification.
No, that is what.
That is what I mean.
Let there be comprehensive counter affidavit so that entire.
No,
thing
but
can-
whether in that.
No, I'm just placing.
No, by way of abundant caution. In case they don't succeed in that, they can have the liberty.
No,
Sever
stay
the
as
order
a-
also.
Stay as a granted, only notice as
Mr. Sao usually does that.
Yes.
Yes, I think Union of India, if you lordship kindly, because their response is very important for my lord to consider. They are necessary.
I'll inform lord. I'll inform.
Can we take up the matter on next Thursday?
As your worship, please.
I'm sorry, 20. I'm not there. Next week again.
First week of April.
First week of April.
First week of April. We shall take up this matter. We'll request Deputy Solicitor General of India to be present in court. And we shall try that all similar matters are tagged and decided together.
Correct. First
Yes.
week of April.
Alright. In the meanwhile, you can just tell us what are the main points involved. 1, 2, 3.
Who will prepare a synopsis for me?
Points first. 1, 2, 3. And then we shall discuss. Then you can refer to your submissions referring to the particular points.
Correct.
No. Let's kindly fix it 9 because I
9. Ninth list this matter on 9/4/2024. First off, in view of the importance of the question and legal question involved, we request learned Deputy Solicitor General for India to be present on the next day.
So they have to take a notice, verbal notice. Extra copy I have to serve.
You accept?
Yes, I accept formula 2 to 4. So far as 1, 2 to 5, I can accept notice.
Mr. So accepts notice on behalf of respondents number 2 to 5. A requisite, it has been served on you.
The advance copy has been served.
Writ petitions have been, number of copies of the writ petition has been served upon him. So stop. And counsel for the petitioner shall be required to serve a requisite number of copies of the writ petition on learned Deputy Solicitor General for India.
Actually, GST Council's counter would be very appropriate.
Correct.
They have to state why they have taken.
Sometimes ministry also direct us to file on behalf of
The Union of India is
Opposite party number 5, they have taken notice because I think they have separate counsel.
Are you appearing for GST Council also?
Sometime, Lord.
No, they are specifically engaging you, or you are
Usually,
as a panel lawyer. You are.
They don't have any panel, so they are engaged in as and when.
You appear.
When you appear.
Yes.
OP number 5, my friend will take minutes.
Yes, taken.
Yes.
You are senior standing counsel.
Yes.
CGST.
CGST.
Our attention has been drawn to the order of this court. This interim order is in this case.
In 3703 minutes.
No.
3703, yes.
Yes.
This case is 370. Our attention has been drawn to which court's order passed in court's interim order passed in WPC number 3703 of 2024 and
1728 of 24.
Last.
1728 of 2024. Dated 31/2024, which admittedly involve similar questions as are involved in the present application. Stop. Considering the said circumstance, it is ordered that in the meanwhile, the respondents shall not initiate any coercive steps pursuant to the impugned order of adjudication without leave of this court.
Item 10.
Published,
May I please, Your Lordship? Under this contempt was filed for non-compliance of the judgment dated 9/1/2024 passed in WPC number 10434 of 2023. I have annexed the judgment, and that is annexed to C/1. It starts from page 6, operative part at page 68. Page 60, para 14. Under the aforesaid premises, the letter dated 17/3/2023 by the election 11 is hereby set aside with further direction to the opposite party number 4, and that is the senior manager and engineer in chief of Indian Oil Corporation Limited, to reconsider the representation of the petitioner and to take appropriate decision within a period of 6 weeks from today. I have submitted Annexure C/2. I have submitted the judgment before the authority. Till date, they are not considering my case. In the other hand, the opposite party, his tender was cancelled. He is supplying the water to the refinery.
They must have gone to apex court.
My lord,
They must have proceeded to apex court.
no information there.
Yes, who is for the other side?
Indian Oil, in the read, Mr. Devraj Mahathir was appearing. He refused to accept the copies.
Issue notice. Issue notice. Yes, speed
Public.
post.
Item 11.
Item 11, this is regarding your payment of your royalty collected during the execution of work. Must be grant me some time after offering the instruction where there was a direction to consider the representation and take a decision. Some time so that I can obtain instruction.
6 weeks time is allowed for the tolerant AGA to tweak instructions and report compliance of this court's order, violation of which has been alleged in the present contempt application. All right. They need it.
Item 12.
May I please, Your Lordship? This writ appeal is directed against the order dated 11/10/2022 and 17/5/23 under Annexure 1 and 2. There is a delay, my lord, in filing the writ appeal, my lord. That is under miscase 7038 of 2023, my lord. There are two miscases, my lord. One is for dispensing with the certified copy, my lord, and another is for delay for condonation of the delay, my lord.
How much?
98 days
98
delay.
days, my lord.
98 days delay.
98 days, my lord.
Where is the order?
Order, my lord, under Annexure 1 at page 12.
One page 12.
Miller. Annexure 1, Miller. Relevant portion, Miller, at page 15, Miller. Running page 15, Miller. May I read out, Miller?
Look, page 15, Millard. Para 6, having had learned counsel for the parties and after going through the record, it appears that the tribunal has passed the order on dated 2/12/1998 with the following observations or direction. As regard the interim player, if there is necessity for manning the post, funds are available for paying his remuneration and work is available to keep him fully engaged, then the applicant be allowed to continue in the post of junior grade typist till 31st/12/1998. Let this way be listed before the date, and on the next date, either counter be filed or submission made as to why the interim order shall not continue further. On 30th 04/1999, the tribunal extended the interim order until further orders. Vital point is, Millard, by the time such order was passed, the petitioner was no more in service since there was no post available and no funds were there to allow the petitioner to continue in service. That is, Millard, that is against the materials available on record, Millard. It is neither case of the appellant present petitioner nor of the respondents that by the time the interim order was continued, extended until further orders by the learned tribunal, the petitioner was no more in the service. It is neither the case of all the record shows that petitioner was continuously continuing in the said post by virtue of the interim order passed by the learned tribunal, Millard. So, para 7, Millard, so far as the claim made by the petitioner in the writ petition is concerned, with regard to direction to the opposite parties to regularize the services of the petitioner as junior typist.
So is this correct that before 34/1999 you were no more in service?
That's why, Millard, the record shows that I placed the.
We have just put a question. You say yes or no.
I was continuing, Millard.
You were continuing,
Millard.
So then you can seek review.
Millard. That was also, your lordship may kindly turn to Annexure 2, page 17. By that order, para 4, having had learned counsel for the parties, and after going through the records, it appears that this court, by the order dated 11/10/22, passed a rigid and speaking order after hearing all the parties. Therefore, this court is not inclined to recall the said order.
You are not sought for review. You have filed an IA.
IA for recalling of that order, Millard. Recalling of that, because that order was against the materials available on the record. All these 5 OS were.
You could have filed a review application. How can you file an application for recall of the order in a disposed of matter?
Millard, that recall petition in.
That recall petition could not have been entertained because writ petition was already dismissed.
Obliged, Millard.
Had it been ex parte order, then it would have been, matter would have been different. But on contest and on your appearance, both the sides were heard and you have filed IA to recall. Is it maintainable?
That was, Millard, that recall petition was by way of review petition, Millard.
No, that cannot be. That could not be.
I humbly concede to a lordship, but the first order itself was against the or contrary to the materials available on the record. Your lordship may kindly turn to their counter, the counter of the respondents, Millard. Your lordship may turn to page 21, Millard. 21, Millard. They have stated that in reply
So that is an error of record. You could have filed a review application. How can you file a recall order by a disposal of matter by filing an interlocutory application? What is the meaning of IA? IA stands for interlocutory. Final, after passing of the final order, you file an interlocutory order.
I humbly agreed with your lordship's view, Miller. But even if Miller, that was a wrong, that was under a wrong nomenclature filed by the previous council, senior council was filed this petition, Miller.
Different jurisdictions altogether. IA and review.
But fact remains, but case record shows that petitioner was continuing till date of hearing of the or disposal of the writ petition, Miller.
Maybe.
All the record shows, Miller, and that also, even if the respondents has gone up to stating or asking the OP number 1 for regularization of his services, Miller. That is filed.
Maybe nothing can be done, Mr. Counsel.
Miller, unless until Miller, that is, since I have worked for 26 years, British appellant has worked for 26 years, Miller. I do humbly agree with your lordship's view that the IA must not be entertained, but that must have been filed a review. But the council, previous council has filed.
You cannot make that submission. Previous council here repeatedly saying that.
Till disposal of the writ petition, Miller.
Even for review, different set of lawyers cannot be engaged. Even for review.
That is what the Supreme Court says.
That may be true, Miller. But unless until this court interferes in the writ appeal, Miller, the order itself of dated 11/10/22 that goes against the materials available on the record. All these materials are available on the record, Miller. Inadvertently, Honorable Single Judge has lost sight of the fact that the petitioner was not there, Miller.
No, we cannot go on like this.
Then unless until Miller, after serving 26 years, Miller, the petitioner has lost his job, Miller. And at the fag end of service, at this age, Miller, at the age of 54, 55, Miller, his services are terminated due to the order of this, order of the Honorable Single Judge, Miller. His services were taken away by the respondents. As because the only on the ground, the Honorable Single Judge refused the regulation that holding that he was no more continuing.
Why did you file IA? What purpose?
Purpose, Miller, to recall that order because that.
So according to you, the order was required to be recalled or reviewed.
That was.
This was your.
My view, Miller.
The
Miller,
petitioner's writ application was dismissed by an order dated 11/10/2022, passed by a learned single judge of this court in WPC bracketed OAC number 3046 of 1998. On the ground that there was an error apparent on record, the petitioner filed an interlocutory application giving rise to IA number 1266 of 2022 in the disposed of matter, seeking a recall of the said order dated 11/10/2022, which has been dismissed by the learned single judge by an order dated 17/5/2022 and 23. Stop. The orders passed by the learned single judge dated 11/10/2022 and 17/5/2023 are being challenged in the present intra-court appeal. Full stop. Next. Learned counsel appearing on behalf of the appellant has argued that there is error apparent on the face of record in the order dated 3046, order dated 11/10/2022. Full stop. Next. We are of the view that the learned single judge rightly declined to entertain IA number 1266 of 2022, which was filed in a disposed of matter for a recall of the order passed by this court on 11/10/2022. Full stop. If according to the petitioner, appellant, a case of review of the order was made out, he could have done so by making an application for review. Full stop. The same having not been done, we do not not been done, the appellant cannot claim any, cannot assail this court's assail the order passed by the learned single judge declining to entertain IA number 1266 of 2022. This appeal, in the court's opinion, has no merit and is accordingly dismissed.
May Miller, the Lordship may give liberty to apply for the review, Miller.
You can do that.
Item 13. Miller, that observation may be there because the writ appeal is dismissed, thereafter review may not be. Your Lordship may observe that. That's maybe hard on merits, Miller. Your Lordship may observe that. I bow down your Lordship's view, Miller, because I was wrongly filed. Your Lordship may kindly give an opportunity because prisoner has served for 26 years, Miller, continuously. So your Lordship may observe that with liberty, I may approach the...
We have not stopped you. You can do that.
Miller, your Lordship may say it is open.
In so many words, we have mentioned that your IA was rightly declined.
But the writ appeal is dismissed on the ground that Miller, that 20...
No further.
Miller, 11/10/22 order has not been clarified, Miller. May pray, Miller, that order may be challenged in review, Miller.
Next.
Well, item 13 may appear next week because before the tribunal I was appearing, so I cannot do this matter.
Requested on behalf of the appellant, list this matter on next week.
Item 14.
In this case, I am challenging the impugned order dated 3/1/24 of the Honorable Single Judge, that is by the Annexure 8/7. But the fact is this, my lord, the respondent one, she filed a petition for probate miscase, and in that case, the petitioner filed a petition under Section 288 of the Indian Succession Act, which was rejected on 6/12/2013. Against that order, he has filed the writ petition on the ground that the probate miscase which was filed, that property is the ancestral property of the present appellant by the Annexure 1. Without impleading, and previously another persons, he has also filed a probate miscase 9/2009 that was dismissed with cost by the Annexure 3. And Annexure 4 was filed by the respondent 1 without impleading to the present appellant as a party when they filed the petition before the learned district judge under Section 288 of the Indian Succession Act, that was rejected. And against that order, I have the challenge before the Honorable Court, and the Honorable Court on 3/1/2005 Annexure 7 has rejected on the ground that with a liberty to challenge the same under section 299 of the Indian Succession Act. That is page 44. And in that case, the limitation is 7 days. Due to the financial condition of the present applicant, they have not approved in time, for which there is a delay of 7 days. And by filing the probate miscase, they have also filed a suit by the Annexure 8. In that suit, they have also made the successor of the present petitioner as a party. But in the probate case, they have not made party.
So whether judgment has been delivered in probate case?
No. That the statement is made that on 4/1/2024 it may for the judgment, but the argument is going on. And the respondent one, they have filed the suit, they have also filed probate miscase.
Why should we why the writ petition ought to have been entertained? The writ petition was filed by you.
Yes.
Why?
They rejected my caveat petition. In the probate case. On the ground that my other successor, they have filed the case, and that was also.
No. 227, the writ petition was not mentioned. The writ appeal was not mentioned.
Two 226 and 227.
Where is question of 226? How 226 will apply?
Against the probate. Our own High Court full bench.
And that is the law, Supreme Court said.
No, they have, I am the advocate.
Assailing and order dated 6/12/2023 passed by District Judge Balasore in probate case number 4 of 2009. The appellant has approached this court by filing WPC number 41847 of 2023. Stop. The said application has been disposed of by a learned single judge of this court by an order dated 3/1/2024. Stop. Apparently, the said WPC number 41847 of 2023 against the order of the learned district judge in probate miscellaneous case number 4 of 2009 was filed under Article 227 of the Constitution of India. Stop. It is well settled legal position that an intra-court appeal shall not lie against an order passed by this court in exercise of power under Article 227 of the Constitution of India, as has been laid down in case of so and so.
Mohammed Saud, 2008. Then confirmed with the Supreme Court in 2010 SCC.
Application is accordingly dismissed. The appeal is accordingly dismissed.
Item 15.
Maybe, pardon me, Lord, item 12 may be permitted to withdraw.
Item 15, my lord.
Maybe permitted to withdraw, my lord.
Item 15, my lord. Item 15, my lord, I am sorry to appear in BC due to illness.
Let him file a memo. Let file a memo.
Okay.
Yes, which item?
Item 15.
Yes.
Item 15, my lord, I am sorry to appear in BC due to illness, my lord. I am for the petitioner, my lord. In this case, my lord, petitioner is challenging the award dated 29/10/2004 in ID case number 275 of 1995, passed by the lower court Bhubaneswar, where the petitioner has been granted no relief, my lord. My lord, the term of reference was whether the refusal of employment to Sri Narendra Kumar Naik, casual labor with effect from 26th October 85 by the management of horticulturist Bhubaneswar is illegal and or justified. If not, what relief the workman is entitled, my lord? My lord, I have given a type copy of the award, my lord. During the award, the last page 8 and brief page 36, my lord. Paragraph 9, after carefully examining the evidence available on record already rendered by the parties, the documents already relied upon by the management and keeping...
You are reading 36. Are you reading page 36?
My lord.
We cannot read.
We have given the type copy, my lord.
Type copy is where?
There is the file, my lord. In the cause list, it is reflected.
Where is the type copy?
In the cause title, it has been cause list, my lord. It is reflected that type copy is filed, my lord. Annexure 8.
Let us see.
That is there, noting is there, my lord.
Scanning.
Yes, please.
My lord. Last page 36 and internal page 8 of the award, my lord. Paragraph 9, after carefully examining the evidences available on record already tendered by the parties, the documents already relied upon by the management and keeping in view of the settled position of law, I am of the view the workman is not entitled to any relief as prayed for. Both the above issues are answered accordingly. Paragraph 10, hence it is ordered.
Yes. Yes, what is wrong? And how can we interfere with such finding of fact?
My lord, rejoinder paragraph 10, that admitted facts by the management is that the workmen have worked from 16/6/1984 to 26/10/85 and paid his daily wages basis after putting signature in the master roll according to the government minimum wages act from time to time. Then in their counter affidavit, my lord, I am placing their counter affidavit. That is the evidence also adduced in the labor court, my lord. Counter evidence, counter affidavit there, running page 40 to the brief.
internal page 3, paragraph 10, my lord. I am placing the
All right,
paragraph 10, my lord. That
We'll see
as
where-
regards to my lord, just I am placing the paragraph they have admitted, my lord. They have
Yes.
admitted that I have completed 240 days work. My lord, this is a legal aid brief. Kindly consider for 2 minutes, my lord.
Yes,
I am
yes, we are
placing-
here for half an hour. Why are you saying 2 minutes?
My lord, my lord, paragraph 10, that as regards to paragraph 12(4) of the writ petition, it is respectfully submitted that though the workman had completed 240 days of continuous service as casual labor on daily wage basis because of the temporary nature of the scheme and his engagement, question of retrenchment compensation does not arise at all. Further, he had never been retrenched or terminated by the management before the closure of the scheme. The petitioner ceased to work after 26/10/85 of his own will after receiving the wages for the period he worked there. Well, this is an admitted view that I have completed 240 days preceding to my date of refusal of employment, which amounts to termination, and section 25F is clearly violated, my lord. My lord, this scheme is over. I don't pray for reinstatement, my lord. I only pray some compensation in view of the illegal violation of mandatory provision of section 25F of the Act. That is in short, my prayer, my lord.
Yes, we'll pass on this.
Obliged.
Thirdly. April 3rd.
Item 16.
Item 16, there are two writ petitions. One has been filed by the management challenging the award, and another writ petition filed by the workmen challenging that not granting back wages. Now, in the meantime, my lord, during pendency of the writ petition, the workman died. And now I got the information that the proprietor of that company, he also expired. So I don't know the position. Now, since the reinstatement is ordered and the workman is died, no fruitful, only some financial implication is involved. So I pray that if your lordship permit, allow me some time to find out if something can be paid to the poor workman. Well, they have been substituted by the legal heirs.
And what is the amount?
I don't know, my lord, because that is the, I can't say because this is the amount which has
Yeah.
70 was paid.
I am in item number 16, my lord.
Restless as that.
Yes, the director Subimuli died recently, my lord. I got the
Not the
information.
company.
It's a company.
Company,
It's a
but
private
whether
limited company.
that company is still, because I call him up many times, but no, there is no response.
Then don't press
I
it.
don't know.
Don't press it then.
Yes.
And counsel submits Mr. P.K. Das.
Next, Mr.
You are Mr.
Sanjay Das.
Mr. S. Das. And counsel states that
My
you
lord,
have any
my
instructions
lord, the
from the
17
petitioner to
wages
press
are
this
not paid
application.
till death, my lord.
This application is accordingly dismissed as not pressed.
My lord, I am for the legal heirs in item number 16, my lord. My lord, award was to reinstate the workman. And the 17B application is pending, my lord. Partly they have paid and till death they have not paid, my lord.
The writ application has been dismissed as not pressed. Do you want something more than that?
My second writ application is there, my lord.
Second,
Yes, 6751.
all right, yes.
It is already a settled position of law, my lord, in view of the death of the workman. If reinstatement is not possible, then compensation is to be paid, my lord. My lord, the first writ petition, it is a corporate brief, my lord. How can it be abated, my lord?
Yes, sir.
And 17B wages are
Any
also
for
not paid, my
IF for setting aside abatement limitation are allowed?
Pardon, my lord?
Allowed.
For workman is concerned. I am not.
17
You are not appearing in
application
that
is
order.
there, my lord?
I am not appearing.
You are not
No,
appearing.
yes, it is a connected.
In the connected case, you are not appearing. You are for presence.
Yeah, I am for presence.
So first matter, you did not press. Second matter also, you are not concerned.
First matter, my lord, how can the pass this way, my lord? My IA is pending for 17B, my lord. Till death of the workman, the 17B to be complied, my lord. They have taken the stay order of the award, my lord.
So you are entitled for compensation on what rate? Idea.
My lord, my past is my lord 207 IA number 2076 by 2021. My 17B wages from 1/11/2014 till date of death 8/10/2021 not paid, my lord.
17?
Several, my lord, pardon.
17?
1/11/2014. 1/11/2014 to date of death, my lord, 8/10/2021. The 17B arrears not paid, my lord. Previously they were paying, they have stopped payment, and my lord, several IA filed, interim orders are passed, they have not complied. In the meantime, the workman died in 21, and so we substituted by the legal heirs in both the writ petition.
IT Act.
The appropriate application should be for non-implementation of the award. Either these apply.
You are not concerned with second case.
A second case, my lord, then in that event, the legal.
Nobody is appearing.
Nobody is appearing. No, my lord, mind be, I am only apprising your lordship regarding the legal position. He can move the application under section 30.
All along from the starting, both the writ petition.
Section 33C2 of the IDA for computation of the wages before the labor court.
The legal heirs.
No.
Yes, legal heirs. Legal heirs can be permitted in 33C2 proceedings.
No, my lord. For Supreme Court decision is that, my lord, if reinstatement is not possible due to the death of the workman, then compensation is to be paid, my lord. And it is a management writ petition, my lord. There are several directors. One director died doesn't mean that company died, my lord.
You are referring to which provision?
My lord, that is 33C2.
33C.
C2. Where any workman is entitled to receive from the employer any money or any benefit which is
workman is no more, my lord.
Mr. Counsel, please don't interject.
Yes, ma'am. Sorry.
Where any workman is entitled to receive from the employer any money or any benefit which is
I have not been able to locate.
33.
33C2.
Capital C.
Capital C2. That is at page 91, my lord. That is the professional. That is page 91.
But this question will arise only after the tribunal holds that he is entitled to.
Yes.
His grievances, he is challenging the tribunal's order.
Only in relating to my lord, not granting back wages.
Yes. So back wages, unless and until we interfere with that part of the order, then only a question will arise as to whether the compensation is to be paid or not.
Yes,
Let us. Where is the order?
Maybe, in my writ petition, that is annexure 4, my lord.
In the second one?
I am not happy.
Oh, no.
65, please. Page 65.
65. Yes, on what ground the Your back wages has been denied. The wages have been denied.
My lord, reinstatement granted, but back wages denied.
Where is, on what ground that has been denied?
Labor court didn't properly apply their mind.
On what ground that has been denied? Can you take us to the order, that part of the order where that has been denied?
You can assist.
Page 9 of the award, that is page 57. Internal page 12. In my brief, that is
No.
page 57, para 9.
Award.
Regarding back wages, according to the settled principle.
Para 9.
Para 9.
That is page 12 of the award.
Yes, my lord. Regarding back wages, according to the settled principle of law is that the relief of reinstatement with full back wages would not be granted automatically, only because it would be lawful to do so. For the said purpose, several factors are required to be taken into consideration. Further, in view of the authority reported in 2004 Supplementary OLR 694, it has been held that when the workman had not worked for the management during the period in question, and he had not proved any cogent evidence that he was not gainfully employed elsewhere, payment of back wages is not justified.
Yes, that is the reasoning assigned for denying the back wages. We do not find any illegality. It could not be proved by you that you were not gainfully employed. Therefore, back wages has been denied. So that is valid reason.
My lord, my claim statement is under Annex of 2, my lord, running page 19 to 28, my lord. In the labor court.
So you have, the court says that based on cogent evidence you could not prove. We are in writ jurisdiction. CWJ.
My lord, when the workman died and a reinstatement is not possible.
Reinstatement is different thing. Reinstatement is a different thing. Reinstatement cannot be granted.
In view of a reinstatement, my lord, in view of a reinstatement, some compensation should have been granted. And my 17B application.
All right, we have understood. We have understood.
My lord.
Both the writ applications have been filed. Questioning and award passed by the industrial dispute by the Labor Court Bhubaneswar. By the Labor Court Bhubaneswar in industrial dispute case number 28 of 2007. First case, WPC number has been filed on behalf of the management, whereas WPC number also has been filed by the workman. First off, by the impugned award, the labor court had directed reinstatement of the employee on the ground that he was terminated from service, unlawfully terminated from service. So stop. The labor court, however, declined to allow the workman, back wages on the ground that he could not prove with cogent evidence the fact that he was not gainfully employed anywhere else during the period he was out of service. So stop. Next, we further notice that the workman died during the pendency of the writ application. These applications, he has been substituted by his legal heirs by an order passed in WPC number 6751 of 2011 after setting aside the order of abatement, setting aside the abatement. So stop. Next, learned counsel for the petitioner in WPC number has submitted that he does not have any instructions to press this writ application. Stop. WPC number so and so is accordingly dismissed as not pressed. Stop. As the second, so far as WPC number so and so is concerned, comma, it will be an futile exercise for this court to enter into the, so far as WPC so is concerned, comma, we find low legal infirmity in the finding of the labor court that the petitioner failed to prove with cogent evidence that he was not gainfully employed for awarding him for directing payment of back wages. Stop. The said order on the point of back wages does not require interference. Payment of back wages does not require interference. Stop. Next. Learned counsel appearing on behalf of the petitioner in CWJC number 65 petitioners in CWJC number in WPC number 6751 of 2011 has submitted that the award of reinstatement has not been implemented by the management, and the legal heirs of the workman are entitled for payment of compensation for the period starting from which the workman was directed to be reinstated till his death. Stop. Next, that the said issue can be subject matter of another proceeding by.
But 17B is to be complied, my lord.
By making an application, whether that application can be made under section 33C.
Under section 33C2 before the labor court.
By making an application before
when the claim
the
is
labor
not
court
decided,
under section 33 capital C bracketed 2 of the Industrial Dispute Act 1947. Stop. These applications stand disposed of with the
17B application, my lord, my 17B application pending.
Item 17.
My lord. In the first case, I am appearing for OP 53, my lord, on behalf of Mr. Mahapatra, my lord. Maybe taken off any other date, my lord.
Who is for the appellant?
I am for the appellant in both the appeals.
So, have you taken his consent?
Yes, my lord, already.
As requested on behalf of respondent number 53.
Yes, my lord. In the first case, respondent number 53, and in the second case, respondent number 4, my lord.
But 12 years old.
Yes, my lord.
I put the opposite party number 55 in the first case.
This matter on 2 weeks.
Item 18.
Only one passed over.
1 week.
Item 19.
May I please your lordship? My lord. The order, your lordship's order that order, it has been mentioned that reading this order, my lord. As requested on behalf of the petitioner, list this matter on 23 to 2024, the court makes it clear that if it is found that the petitioner lacks bona fide in filing the present petition in the nature of public interest litigation, the court will consider imposition of exemplary cost. This is your.
So what is this about?
Yes. My lord, the petitioner has filed the PIL as an aggrieved person, a victimized person. It is the law of the Supreme Court, Honorable Supreme Court, that any person being aggrieved and victimized can file.
You start from the Supreme Court's decision, or you tell us what is the case about?
Case is, my lord, the MCL authorities has then if minor, they are cutting the road, and have not given the compensation amount, and some person has been acquired and other persons has not been acquired. So the people cannot be displaced due to non-payment of compensation. There are so many allegations against the MCL authorities.
So many cases should have been filed. If there are so many allegations, so many cause of actions, then so many cases ought to have been filed. Why this PIL from 2014?
PIL means maximum persons cannot come forward for filing these individual cases. But therefore, this Honorable Supreme Court has given guidelines that one aggrieved person can move this Honorable Court or Supreme Court to consider this matter. I am giving the law, my lord. 2010, 3 Supreme Court cases, 402. At para 44, my lord, this court, while interpreting the words person aggrieved in Jasbhai Motibhai Desai versus Roshan Kumar, observed that SCC at page 68 to para 35, the traditional rule is flexible enough to take in those cases where the applicant has been prejudicially affected by an act or omission of an authority, even though he has no proprietary or even a fiduciary interest in the subject matter. That apart, in exceptional cases, even a stranger or a person who was not a party to the proceeding before the authority, but has a substantial and genuine interest in the subject matter of the proceeding will be covered by this rule. While the petitioners are thousands in numbers, they may not, in their capacity, can move this Honorable Court.
What is this matter?
They have authorized.
Please sit down. Let us understand. You will not tell us the facts. Please sit down.
My lord?
You please sit down for a while. Let us understand what is the matter about. Yes.
Millers, this relates to MCL acquiring lands for mining purpose. Lands have been acquired. Compensation has been paid. We have provided almost all facilities we have given in latest counter mirrors. I filed a further affidavit. What we have provided for them. We have provided everything. Whatever permissible under the law. Compensation, roads are also being water being sprinkled at times of necessity. Some people have been provided land and house. Everything has been done. I have elaborated in my writ application. Here, and all statutory compensations. Here, this fellow is an employee continuing in the MCL. He has some grudge. His wife is not being provided for employment. In that, for that person, he has tried to be the representative of everybody and has filed this PIL. Not a single other person has been added to this. We have specifically stated this.
So has he filed any reply to this?
Yes, I have. No, he has not. He has not filed a reply to that. I have specifically taken that he is a. Your Lordships have also dealt in the very fast order. If your Lordship will kindly see when your Lordships 31/2015, this Honorable Court declined to pass an interlocutory order. There they have said, categorically dealt also this matter. Paragraph 3 in the order dated 31/2015. We're searching for that. Should I place it?
Yes, yes, it is there.
I've got extra copies, your Lordship.
Yes, yeah, the order is there with us.
Yes. Third para. The MCL in its counter, while stoutly denying the above imputations, has questioned the bona fide of the petitioner in initiating this case. According to the petitioner, he is in employment in Jagannath Colliery, but for his misconduct, he is facing disciplinary proceeding, and that the authorities of the MCL have also filed a FIR against him. While alleging that the petitioner has been insisting for employment of his wife and that he is in the habit of indulging in filing frivolous litigation, the MCL has asserted that the lands have been acquired by following due procedure of law for mining operation, while contending that meanwhile 981 families have received compensation in lieu of plot in resettlement site as per R&R policy. The government of Odisha have been shifted elsewhere. MCL in categorical terms has asserted that blasting are being conducted with the approval of Director General Mine Safety. A reference has also been made in this regard to the report on study advice of optimization of blast design parameters at the Lingaraj open cast project to control ground vibration within safe limits of the safety of structures in the periphery of the mine. To negate that, the operation are being made in the vicinity of the households. It is stated that MCL, as per corporate social responsibility, has constructed roads, provided drinking water through boring facilities. According to it, separate roads have been constructed for movement of heavy vehicles as it is necessary for keeping the colliery functional. It is averred that while carrying out its activities, it has taken necessary steps to avoid any damage caused to any human being or to domestic animal. Then further minutes, I have also filed recent and further affidavit as per the direction of this Honorable Court, where I have explained in detail what I have done, how much paid, but everything I have explained in the affidavit dated 7/3/24. We have got environmental clearance from the Pollution Control Board, everything I have given.
Yes.
And as page 37 of the additional affidavit, I have given how much we have paid for the CSR activities, everything I have said.
Yes. How much cost will you pay? How much cost? How much cost? We are going to impose cost.
This is the law, as per law, he is filed by law.
According to you, as per law, but according to us, the cost is required to be imposed. If the Supreme Court says, according to you, that we should entertain, but we are imposing cost.
And if a poor person, what his cost?
We have understood who are poor and who are what.
There's no source of income. He's only after being discouraged from service, he's not able to maintain his family.
And therefore he filed PIL.
No. He has filed PIL since 2014, and this Honorable Court has approved that yes, you are able
All right. Tell us how much.
My lord,
How much? How much cost?
your lordship, what
Okay.
can I do?
I will decide. We will decide then. Cost we will decide. The present public
This may please be withdrawn.
learned counsel for the petitioner seeks permission to withdraw this writ application, which is accordingly dismissed as withdrawn. You file your memo, withdrawal.
Item 20.
Presence.
My lord, in item 20, my lord, we are filing the counter affidavit in the
Item
20, my lord. Filing the counter affidavit today, my lord, in the counter. Soft copy also, copy of the same, my lord. Lord Sinha.
It is stated by learned counsel for the opposite party that a counter affidavit is going to be filed today.
Yes, ma'am. My lord, already ready.
I filed.
Yes, ma'am. In
Counter.
counter to be filed. In counter, I will file today, ma'am.
All right, counter affidavit is going to be filed today in the registry. Full stop. A copy of the said counter affidavit has been served upon learned counsel for the petitioner today itself. Full stop. As requested on behalf of the petitioner, list this matter on how much time?
Next week, ma'am.
On 1 week, 2 weeks, so as to enable him to consider the said counter affidavit.
Item 21.
May please.
Item 21. Impugn order is at Annexure 1. It starts from page 14. Before, see the issue, my lord, during pendency of a criminal case, whether one is entitled to get promotion or not, that is the short question is to be decided here. Before going to the impugn order, my lord, I will bring my lord's notice to the prayer made before the honorable single judge. What was the prayer, my lord? May I bring my lord's notice to the prayer made in the writ petition? I have not annexed the writ petition. Page 12 of the writ petition prayer mail.
Yes.
It is therefore prayed that this honorable court may graciously plead to issue writ of nature of mandamus directing the opposite party to give ad hoc promotion to the petitioner from the rank of executive engineer to the superintendent engineer civil level 2 with immediate effect. This was the prayer made before the honorable single judge. Then I will bring my lord's notice to the order passed by honorable single judge. It starts from page 14, my lord. A relevant portion is at page 46, paragraph 20.
Annexure?
Well, annexure 1 of writ appeal, my lord, starts from page 14, 1-4, my lord.
Annexure 1 is?
Order of the honorable.
All right.
Passed in the writ petition, my lord. I will draw my lord's notice, para 20, page 46. May I read?
Yes.
In view of the factual and legal matrix I discussed above, this court is of the considered view that if the petitioner has been exonerated from the charges leveled against him in a disciplinary proceeding, which was initiated on the self-same facts merely because the vigilance case is pending, though the standard of proof in both the cases are different, and even though the standard of proof in case of this is lower than the vigilance case, for that ipso facto cannot deny the petitioner the benefit of promotion, which has been kept in a seal cover. Consequentially, this court directs the opposite party to open the seal cover and extend the benefit of promotion to the petitioner if he is otherwise entitled to get the same with all consequential benefits, with effect from the date his immediate junior has been given promotion to the next higher post. The above exercise shall be done within a period of 3 months from the date of communication. Why this finding? Because of para 16, my. I have shown my lords the prayer made in the read petition. And your lords may see para 16 at page 42. May I read? This finding is incorrect. Incorrect, my lord. I will drop my lord's notice. I have filed a memorandum, my lord. It is with my lords, my lord. I have filed a memorandum. There are annexed one document. That is the document, the judgment of this honorable court, wherein he has approached this honorable court in 482 to quash the criminal proceeding as he has been exonerated in the departmental proceeding. Your lordship did not entertain his prayer. I have given that judgment. And the memorandum, I have submitted it. Page 65 of my memorandum. Let's see page 65.
Of your appeal.
I have filed a memorandum annexing all the certain documents, including the judgment of this honorable court passed in 4.
What is there in that?
There, he has challenged that criminal proceeding. This man, under section 482, this honorable court held that no, has not been completely exonerated in the departmental proceeding, so criminal proceeding cannot be quashed. But in the read petition, honorable single judge has held, as he has been exonerated in the departmental proceeding, the criminal proceeding has lost its force.
No, but that we can see whether he has been exonerated or not.
Yes, admitted fact he has been exonerated. There is no dispute that he has been exonerated in the.
So if he has been exonerated, then it has been incorrectly recorded in the order under section 142, 482 that he has not been exonerated fully.
No. Honorable single judge has held that on 482 he has been exonerated technically. So you'll also make page 65 of the judgment. This man has filed this Chakradhar respondent.
Yes.
Page 65, you got it?
Yes.
Chakradhar Prasad Gantat versus State of Odisha.
Yes.
That is CRLMC 562 of 2021. In that case, he has fled to quash that criminal case, vigilance case. All the judgments which has been relied by honorable single judge in the read petition, this judgment has been taken note of. And the finding is at page 75.
Yes.
May I read? So the net result of the above discussion is that even though the petition is said to have been exonerated from the charges in the departmental inquiry, since it was not on merit, cannot be said to have been a case of honorable exit.
Yes.
So that criminal proceeding is continuing. And there is no dispute to that, that criminal case is not continuing. Yes. So if that criminal case is continuing, the only question for consideration before my lords, whether he is entitled to promotion or not. That aspect has been decided by this honorable court. And also your lordship has decided the issue during pendency of a criminal case, one is not entitled to promotion. That is the short question. I have relied upon all the judgments and also I am relying my lord's judgment. My lord's judgment is WA number 16 of 2014. Lordship has passed the judgment on 6/3/2024.
Following Joseph Bari.
Yes. My lord, relying the judgment passed in Joseph Bari, I have also, in that memorandum, I have also given that copy of that Joseph Bari also.
So that is the only point involved.
That is the only point involved. If your
Let
lordship,
him argue.
yes, but if your lordship hold that no criminal case, then we have no case.
Lordship, at the outset, I want to Lordship rely upon Lordship's judgment past Lordship. That is writ appeal number 16 of 2024, Lordship. Recently, Lordship rendered this judgment. Lordship, kindly come to the operative part. Relying upon Lordship, that is, Lordship's absolute pointed that Joseph Barrick's case, Lordship, this judgment has been rendered, and Lordship, prior facie Lordship, and it appears, and Lordship has given finding at last sentence, the para Lordship, have been taken and last page and considered before reaching a conclusion that a government server did not have any right to be considered for promotion during the pendency either of department proceeding or a criminal proceeding, Lordship. In Lordship, in considering the Joseph Barrick's case, Lordship, this view has been taken. And admittedly, in this case, Lordship, I have been exempted from the department charges, and Lordship, criminal proceeding is admittedly that is still pending, Lordship. Lordship, for a moment, Lordship, kindly come to the judgment. Joseph Barrick's case, Lordship.
That is page 51 of my memorandum.
Yes, I'm just looking at it.
Yes.
Lordship, kindly come to Lordship, I'll start reading from para 8, Lordship.
Yes.
Lordship, the court has been shown a compilation of memorandum of such and such, Lordship. None of them envisages a permits, grant a promotion to a government.
Paragraph 8.
Para 8, Lordship, I am reading, Lordship.
Yes. The court has been shown.
Lordship.
Yes.
Court has been shown a compilation of office memorandum. The notifications issued by the government of Odisha from time to time. These includes OM dated, the office memorandum, Lordship, dated 18th February 1994, 4th July 1995, 1st November 1997, 20th January 99, 20th May 2012, 29th April 2017, and 17th June 2021, issued by the General Administration Department. None of them envisages or permits grant of promotion to a government servant either on regular or on ad hoc basis during the pendency of a criminal case involving such government servant. Then, Lordship, relying upon such judgment, Lordship, the next para I am reading, Lordship. Further, in terms of the law explained by the Supreme Court in such and such, Court 5th October such and such, and the judgment dated such and such, there is no right of the government servant to be considered for the promotion during pendency of either dependency proceedings or criminal proceedings or both against such government servant. The plea of the Law and Council appearing with the respondents that they should be granted at least one ad hoc promotion is also without any legal basis in light of the above and settled position of law. It is clarified that when the criminal proceedings end in favor of a government favor of government servant by way of an acquittal, and such government servant also stands exonerated from the departmental proceedings, then notwithstanding the superannuation of such government servant, the notional benefits attaching to the promotion this due to the government servant would be calculated and the pension fixed accordingly. So these are the views taken by the division bench, Lordship. And prior to that, Lordship, kindly come to only para 5, Lordship, because para 5 of the same judgment, Lordship. Where, Lordship, my case has been taken care of, Lordship. This is my case, para 5, Lordship. Lord Counsel, appearing for the respective respondents, argue that on account of the long years of the pendency of the criminal case and with the impending prospect of many of the respondents, superannuating in immediate future, one equitable solution would be for this court to direct the appellants, State of Odisha, to grant them ad hoc promotions in support of such plea, reliance placed on an interim order passed by this court in 27 March 23 in writ appeal number 321, present case, Lordship, present appeal. However, it is pointed by Mr. Khuntia, Lord and Additional Government Advocate AGA.
Minister, why are you referring to the arguments? What is the law laid down in this case?
But Lordship, I have been given, Lordship, in this case, my case has been taken care of. Why my case is something different from other cases, it has been taken care of, Lordship. So that's why para 6 and 7 is very important, Lordship. Para 6, Lordship, kindly see. However, it is pointed by Mr. Khuntia, Lord and Additional Government Advocate AGA, that in writ appeal number 321, the present resolution 2022, the respondent has been exonerated in the department proceedings, and the report sent by the Special Judge Vigilance to this court showed that the trial in TR number 50/14 was progressing very slowly, with only 3 witnesses having been examined. Accordingly, this court in the said case directed the trial court to conclude the entire trial and deliver the judgment on or before 1st August 2023. It is in those circumstances that no interim order was passed in division bench staying the order of this London single judge. The said writ appeal has been directed to listed on 10th August 2023. And Lordship, before coming to the merits of the case to convince a Lordship what is exception in my case, Lordship, kindly 3 to 4 orders of this case in this writ appeal, Lordship. Lordship, order dated 5/7/2022 for Lordship.
Order dated
5/7/2022, Lordship. Order number 3. Lordship, para 3 I am reading, Lordship. Lordship, got it, Lordship?
Yes.
Para 3, Mr. Sukant Kumar Dale, counsel states that since he has put in an appearance on behalf of respondent, no formal notice is required to be issued. He prays for a direction to the Court of Special Judge Vigilance, Bhubaneswar, for concluding the criminal proceeding pending since on 14 at the initial stage itself within a fixed time frame, as the petitioner is stated to retire on superannuation in the year 2023, Lordship. Then, Lordship,
this distinguishes your case.
No, Lordship, I'm showing my bona fide, Lordship, because
bona fide is different.
I'll come to Lordship. Lordship, kindly bear only 3 orders I will show, Lordship. Then I'll come to merits, Lordship, because it is very important for adjudication, Lordship. Then, Lordship, come to para 5. Para 5, Lordship. The Special Judge Vigilance Bhubaneswar is directed to decide the pending applications on the next date fixed on 7 July 2022 or within the next 1 week thereafter, and proceed to post case for consideration of framing of charges before the next date fixed before this court. Then let's kindly come to order dated 28/10/2022. 28/10/2022. That is at para 5, Lordship. Let the Special Judge Vigilance, Bhubaneswar, file a fresh report. He is directed to pass appropriate orders to secure presence of the cited witnesses so as to facilitate the early conclusion of the trial.
Mr. Counsel,
Then, Lordship.
in this writ appeal,
Lordship.
these orders have been passed.
Lordship. Then, Lordship, kindly only one order, Lordship. Can you come to order 27 or 23? Order date only para 6, Lordship. 27, Lordship. 27/3/2023. 27/3/2023, Lordship.
Yes.
Again, Lordship, deciding the case of the status of the case starting from para 4. I'm reading only 3 paragraphs, Lordship. The last report sent by Special Judge Vigilance Bhubaneswar stated that trial case number 50 to 14 is still pending in progress. only 3 prosecution witnesses had been examined till then. Then, Lordship, para 5, a fresh report be called for Special Judge Vigilance Bhubaneswar as to current status of the trial in TR case number 50 to 14. Then, para 6 is very important, Lordship. The court requests the trial court to conclude the entire trial on or before 1st July 2023 and deliver judgment in case on or before 1st 2023. The parties in the real will cooperate with the trial court to adhere to the above time schedule and not seek unnecessary adjournment. These directions are been issued since the case in the trial court has been pending since 14. So despite your Lordship's direction, it is still remaining same position, Lordship.
That is different, but the question remains
Lordship.
whether it is an admitted fact that criminal case is pending.
Lordship, that's their Lordship.
Pendency of the criminal case.
Lordship.
You can.
Lordship, despite my humble submission before coming to the merits, Lordship, despite your Lordship's several directions and your Lordship fixed the deadline, still then, Lordship, the criminal
That
case
does not amount to acquittal.
No, I'm not on the Lordship. I'm not on that Lordship.
Yes.
Because my humble submission at this stage, Lordship, at the Lordship, if the state's inaction, I will suffer, Lordship. That is my humble submission for Lordship. And Lordship, despite Lordship's direction, they are not moving at all, Lordship.
All right.
Then Lordship kindly come to the notification. I'm just bringing Lordship's kind attention. Only Lordship, this promotion of the employees, Lordship, is governed by using law, Lordship, that is.
No, is this your case that this judgment does not apply in your case?
Lordship, I'll convince it not apply in my case, Lordship. Lordship, there is Odisha Services Criteria for Promotion Rule 1992. It is, Lordship, the only rule governing the field regarding promotion of the employees, Lordship. And Lordship, that is the Odisha Civil Services Criteria for Promotion Rules 1992.
This is the book 246.
OCS, CCS.
Yes, Lordship, 240.
No, it's not the criteria.
Odisha Civil Services, in that compilation, Lordship.
Book is
CCL.
Yes,
CCL rules.
Yes, Lordship.
In that book,
Yes.
246.
246 pages.
not an
Yes.
Lordship, Rule 3 speaks of criteria for promotion, Lordship, Rule 3. Notwithstanding, Lordship, got it, Lordship?
Yes.
Notwithstanding anything contained in the recruitment rules, Lordship, A, all promotion up to the post of grades of different services, civil post under the state government shall be made by selection. B, selection for such promotion shall be made on the basis of merit and suitability in all respect with due regard to the seniority, and the names of persons included in the select list shall be arranged in order of seniority in the feeder service grade, provided that any junior officer of exceptional merit of suitability may be assigned a place higher than his seniors, and in such case the assignment of higher position to the junior officer shall be limited the name to the name of the batch of year allotment of, except where an officer of the earlier batch or an officer of allotment or year of allotment is found unsuitable for promotion, provided further that where promotion is made for different services or posts and no common seniority among such officers exists.
So what do you want to say?
So, Lordship, in rules list, there is no prohibition.
All right.
Lordship, if in,
all right.
Lordship.
So as to convince you,
Lordship,
it says
Lordship,
merit and suitability in
Lordship.
all respect.
Lordship.
So whether you are suitable or not,
Yes.
it will depend on whether you qualify or not.
Yes, Lordship. That's why, Lordship, kindly come to next notification. That is perhaps in that compilation there, Lordship. The next page, perhaps, Lordship, that is called.
How do you say that this barik will not apply in your
Lordship,
case?
I'm coming to the Lordship. Lordship, can come to the next perhaps 250, page 50.
Page
250, Lordship.
Please keep in mind that don't waste your court's time.
No, I'm trying my best.
And you may lose your case. You should not lose the court. So if you have some case, if you are of the view, of course you address, but keep this in mind also.
Definitely, Lordship. I'll try my best, Lordship.
Please.
Lordship should consider my grievance, Lordship. I'm not.
No, we are ready.
Lordship.
We are ready, but always keep in mind,
Lordship,
that you should lose the case, but not the court.
Lordship, grateful, Lordship.
So if we are finally of the view that you have wasted the court's time, then you will losing the court.
Lordship, I'll try my best, Lordship.
Yes, we are also here.
Kindly come to page 250, Lordship.
Yes.
Lordship. Here, Lordship, the government came with office memorandum, Lordship, that is 4th July 1995, Lordship.
So this was not applicable in case of Barik?
No, Lordship.
Barik, it was not applicable.
There is, Lordship, there is some, Lordship, relaxation where my case can be considered.
All right.
Lordship, kindly, Lordship. Lordship, just I am to read the entire Lordship, the notification. Promotion of government servants against whom disciplinary criminal proceedings are pending procedure to be followed. Here they have come up with this guidelines where both the criminal and disciplinary proceedings pending. What should be the method to consider that promotion case, Lordship? The procedure to be adopted by the DPC while selecting employees for promotion of the next higher grade when any disciplinary criminal proceedings is pending has been laid down in GA Department Office Memorandum number 3298 General dated 8 February 1994. It has come to the notice the government that difficulties are being experienced in the case where disciplinary proceedings, criminal prosecutions against the government servants are pending for long period without being disposed of. This delay is unfairly depriving of such government servants from getting promotion to the next higher grades. The government, after careful consideration of all aspects and the partial modification of the instructions contained in GA Department Office Memorandum number 3298 General dated 18th February 1994, referred to above, have been now pleased to decide as follows. One, the disciplinary authorities, while framing charges against the delinquent government servant, should carefully consider the circumstances while deciding whether the delinquency merit framing of charges under Rule 15 or under Rule 16 of the OCCC Rules 1962. In the cases where a minor penalty proceeding have been drawn up under Rule 16 of the OCCC Rules 1962, the sealed cover procedure shall not be applicable. Where the major penalty proceedings have been drawn up under Rule 15 of OCCC Rules 1962, the procedure in J Department Office Memorandum number 3928 dated the 18th February 1994 should be followed. In the cases where the criminal prosecution disciplinary cases against the delinquent government employees have not come to an end, even after expiry of 2 years from the date of meeting of the first departmental promotion committee, the appointing authority may review the withheld promotion cases provided the delinquent government employees are not under suspension to consider the desirability of giving the ad hoc promotion, keeping in view following aspects: whether promotion of the employees will be against the public interest, whether the charges are grave enough to warrant continued denial promotion, whether there is any likelihood of the case coming to the conclusion of the near future, whether the delay in finalization of the proceedings, departmental or in a court of law, is not directly or indirectly attributable to the employee concerned, whether there is any likelihood official position that the employee may occupy after ad hoc promotion, which may adversely affect the conduct of the department case criminal prosecution. Then, Lordship, in case of appointing authority consider that it would not be against the public interest to allow ad hoc promotion to the employee concerned, his case should be placed before the next DPC to be held in the normal course to decide whether the employee is suitable for promotion on ad hoc basis. If the employee is considered suitable on the basis of the totality of his record of service without taking into account the pending disciplinary case of criminal prosecution against him, on order of promotion may be issued, making it clear that the promotion is being made purely on ad hoc, and ad hoc promotion will not confer any right for regular promotion, and the ad hoc promotion shall survive until further orders. It should also be indicated in the orders of the government reserve the right to cancel the ad hoc promotion and any time and revert the employee to the post from where he was promoted without assigning any reason. Therefore, all other conditions contained in the official office memorandum remain unchanged. So, Lordship, my humble submission, Lordship, can look at my case. I am an executive engineer, Lordship, and I do initially the FR lodged by the vigilance. My name was not there, Lordship. And subsequently, what they have done, Lordship, relying upon the provision of the OPW code, because the provision under the OPW code is there, Lordship, 10% of the work has to be check measured by the executive engineer. And when the cost of the work is more.
Now we have come to the merits of the criminal case.
No, Lordship, no. I'm not merit, Lordship. I'm just, Lordship, correlating with this notification to my position, Lordship.
Now you should
Because,
stop.
Lordship.
The appellant is aggrieved by an order passed by a single judge of this court dated 2/12/2021 in WPC number 10919 of 2021, whereby the appellant state of Odisha whereby the single judge has disposed of the writ petition filed by the respondent in the following terms, paragraph 20. First off, it has been submitted on behalf of the appellant that this is an admitted fact that a criminal case is pending against the petitioner, against the respondent. First off, a departmental proceeding was also initiated against him in relation to the charges which are subject matter of the criminal proceeding also. First off, in the said departmental proceeding, the petitioner, the respondent has been exonerated of the charges. First off, however, the criminal case is still pending. First off, it is contended that in view of a division bench, he has contended that it has been clearly laid down by a division bench decision of this court in case of State of Odisha versus Joseph Barik that during the pendency of the Joseph Barik reported in 2023 volume 2 ILR CUT 361 that a government servant has no right to be considered for promotion during the pendency either of departmental proceeding or of a criminal proceeding or both. First off, he submits that the decision, impugned decision rendered by the learned single judge is in conflict with the said division bench decision of this court in case of Barik. First off, he has also argued this is the only point which you are taking?
Yes, that's the only point.
Next, learned counsel appearing on behalf of the respondent, on the other hand, has drawn this court's attention to various orders passed by this court in the present appeal, expressing concern over pendency of criminal case since cases with criminal case pending is when
2013.
2010, Lordship. 2010.
No, when you were made accused.
Lordship, 2013, Lordship. 2010 FIR, Lordship. 14 charge sheet, they include my name, Lordship.
Against the pendency of criminal case against the appellant since 2014
Against the respondent, my lord.
against the respondent since 2014. Where are those orders? Where are those orders?
Lordship. That is order dated lordship starts from.
Hmm.
22/7 lordship that is starts from. Lordship 5/7 starts from 5/7 on 22 lordship.
5/7 there is no order.
5/7 lordship first on my request lordship.
That is your request.
Only lordship and last order lordship is thing lordship that is order dated. Order dated lordship 27/3 sorry.
By disputing the present appeal, expressing concern over pendency of criminal case against the respondent since 2014.
14 dated 29/7/2022. Dated 5/7/2022, comma 29/7/2022, 28/10/2022, 27/3/2023, and 27/3/2023.
Lordship.
But stop. He has submitted that despite observations made by this court, the trial has not concluded and the respondent has been made to suffer in the matter of grant of promotion on the ground of pendency of the criminal case. So stop. He has submitted that the case of the respondent is thus distinguishable from the case decided by this court in case of so and so Barik. First off, he has also drawn our attention to the OCS Odisha Civil Service bracketed criteria for promotion rules 1992 with special reference to clause 3 thereof to contain that it does not provide that the said provision does not bar grant of promotion on the ground of pendency of a criminal case. Any other thing?
Lordship, and one more aspect, Lordship.
What has you have submitted, not beyond that?
I have left one thing, Lordship, because your Lordship disposing the writ appeal, another valid ground also, Lordship. The selective approach of the state government on the out of same Lordship, they have given promotion to the co-employees, Lordship.
That the state has been selective and selective in granting in the matter of grant of promotion to its employees on the ground of pendency of criminal cases.
Lordship. We counter that admitted, Lordship.
Next, in case of
95 circular, I have relied, Lordship.
Joseph Barik bracketed Supra, the Supreme Court a coordinate bench of this court has in no uncertain terms held that a government servant does not have a right to be considered for promotion during the pendency either of departmental proceeding or a criminal proceeding. Full stop. The said decision has been followed recently by this court in case of Principal Secretary Panchayat Raj, followed in its decision dated 6/3/2024, rendered in Principal Secretary Panchayat Raj Department, Government of Odisha and others versus Devi Prasad Nanda in WA number 16 of 2024. Stop. It is true. You have relied on that is the
95 of this memorandum, Lordship. That
yes, 4/7/1995.
97, Lordship.
He has also relied on an office memorandum dated 4/7/1995 to submit that the authorities ought to have considered the respondent's case for grant of ad hoc promotion. First off, the said office memorandum has been taken note of by this court in case of Joseph Barik Supra.
And that has been withdrawn, my lord. That has been withdrawn. That I have annexed that notification.
When was that withdrawn?
That has been withdrawn on 29th April 2017. Your lordship can find it from
17.
My lord.
Where?
Page 85.
Stop. It has been pointed out by counsel for the appellant that the said office memorandum dated 1995 has subsequently withdrawn.
By notification dated 29th April 2017, my lord.
By notification dated 29/4/2017, bracketed annexure 6
page 85 my to the memorandum, my lord.
Annexure 6 the memo of appeal.
Well, no, memorandum I have given your lordship.
Memorandum.
Well, I have given that memorandum.
Read appeal. Stop. Next. Be that as it may, considering the it is true that we also express our concern over long pendency of the criminal case against him, against the respondent, which has resulted into denial of consideration of his promotion on that sole ground. First off, the orders passed by this court in the present order speak for themselves and read as under 20. Five seven 2022. वो कर दोगे paragraph 5 quoted. 29/7/2022, paragraph 2 quoted. (28 10/2022), paragraph 3. Paragraph 3 and paragraph 5. Paragraph 3, 4, 5. (27/3/2023), paragraph 4, 5 and 6. Full stop. Be that as it may, comma, in view of the law laid down by the division bench in case of Joseph Barik, which has been followed by the learned, which has Barik, comma, in our opinion, the decision, impugned decision rendered by the learned single judge cannot be upheld, which requires interference. So stop. Accordingly, the impugned order so and so is set aside. This appeal is allowed. So stop. Let a copy of this order be communicated to the learned. Where is the matter pending?
Lordship, Vigilance Judge Bhubaneswar, Lordship, Special Judge Vigilance Bhubaneswar.
Is communicated to learned special judge Bhubaneswar. We will see.
Lordship, Lordship, by virtue of this writ appeal, I have been given promotion to the one Lordship ad hoc post. Lordship. I was executive engineer. I have been promoted to superintendent engineer, Lordship.
Because of my lord's interim order, your lordship.
Yes.
We have passed.
And Lordship, and I will continue only 2 months, Lordship, is my verge of retirement, Lordship.
The interim order stands vacant. Yes.
Lordship,
Public.
Lordship, my humble submission, Lordship, because Lordship can say there is a Lordship may say to trial court, Lordship, because despite Lordship's direction, they are not Lordship.
That aspect we will see. Can you just remind?
Nothing, Lordship, nothing is.
Perhaps last.
When did you file your what?
Prior to Lordship this question. Prior to Lordship order of Lordship, that is Lordship order dated. This was pending since 2021, Lordship, question of
Yeah, we asked when and you are saying you file your quashing application in 2021.
Lordship. For discharge, Lordship. Before framing of charge, I had come, Lordship. And personal Lordship action, I have appeared, Lordship, in my request, and charge has been framed, and trial is on, Lordship, on my request, Lordship. And despite Lordship's direction, only 3 witnesses have examined, and nothing is done, Lordship. So some direction must be there, Lordship, otherwise, Lordship.
The communication to the court is enough.
Lordship, clearly see, Lordship, given a direction to fixing a date to deliver judgment, they are not acting upon, Lordship. But this is sorry state of affairs, Lordship. Only I say, Lordship, because the fault of the state, I will suffer. That is my only submission, Lordship. Because Lordship, in the selective approach and Lordship and the inaction of the state, the citizens are suffering, Lordship.
Item 22.
May I please? My page 28A, annexure 4 is the order passed by Honorable Single Judge. My lord. 4, my.
No, that is annexure 3. What you look? That is annexure 3.
Yes,
Three
yes,
annexures
my
in the
lord.
writ
Yes,
appeal.
yes, my lord. Sorry, my lord. That annexure 3, I read just next page, so that annexure 3, my. The order passed by Honorable Single Judge. Next page, the order is, but first page, the court title. Next, this, because this is a transfer case from the tribunal, so that is the court title of that case, fellow.
Yeah.
This is a case of regularization. The Honorable Court has come to a conclusion since he has continued against a sanctioned post. So as he has completed more than 10 years of service, he deemed to be regularized. So this is not based on record as per his governments and as per his documents appended to that. He annexures made to the writ petition. I will draw my lord's notice to paragraph 7, 8, and 10.
No, the observation is
Yes,
that benefit claim cannot be denied, especially when similarly situated persons have already been extended with them.
that is also wrong. It's not similarly situated person has been given benefit. That is also not a fact. And I have also brought the file of that case which has been relied. That is complete different case, my lord.
We cannot see that file.
I am not. Yes, madam. Yes, madam. That I have avoided in my readable. That is totally different from that. This is
You must have a statement in the counter affidavit also.
in the counter affidavit. That was not the ground before in the writ petition. In our counter, we have taken the ground that he has not worked against a sanctioned post. So he can. That is the only ground we have taken that he cannot be regulated in view of the judgment of the Honorable Apex Court in the case of Umade. Honorable Single Judge has held that we have not denied to that aspect. Let's see paragraph 6, 7, 8, 7, 8, 9. Page 33, mile. The petitioner specifically pleaded in paragraph 6.7 of the writ petition to the following effect: that while the matter stood as such, the respondents prepared a list of DLR NMR employees in the registration office in order to regularize their service so that they can maintain their family. Now, the gradation list by annexure 4, it is found that the applicant at serial number 39 and his appointment is against the sanction post by IGR during the year 1992. The applicant was also appointed by the competent authority and a copy is enclosed to the gradation list prepared by the respondents through the applicant. Enclosed to the gradation list prepared by the respondent through the applicant has rendered more than 10 years of service and his appointment to the sanction post, and moreover he has requisite qualification for the post. So the authorities should regularize service without any further delay. Then our arguments in the counter. A counter affidavit has been filed on behalf of the opposite parties 1 to 5 on 5/12/2012 in response to the pleading made in para 6 of the has been given in paragraph 10 of the counter affidavit, which reads as follows. That in response to para 6.7 of the way, it is humbly submitted that the averments made by the applicant that the respondents have prepared a list of a DLR NMR employees in registration office in order to regularize their service are not correct. Sri R.K. Patnaik was applicant. Respondent was engaged as night watchman cum sweeper on part-time basis on 1/3/2004 after the promulgation of the ban period declared by the government, which is 12/4/1993. No such gradation list has been prepared by the respondent. Only a statement showing the engagement of DLR NMR employees in registration organization has been worked out by the respondents. Yet there is no sanctioned post of night watchman cum sweeper sanctioned by the government in sub-register of service of the applicant does not arise. I'll bring my lord's notice to the document he has relied on, which the Honorable Single Judge has said that that is a sanctioned post and it has been admitted. May I bring my lord's notice to
The order has been implemented.
This order has not been implemented because this has been stayed by my lords.
Yes.
Only point I'll point out, Mala, if there is a sanctioned post and he has continued more than 10 years of service, then whether will be covered under that judgment of that, thereafter I will come to your lords. May I draw my lord's notice to the document he has annexed to his writ petition, which has been relied upon by the Honorable Single Judge. Your lords may turn to page 9 of the writ petition. Page 9 of the writ petition. May I bring my lord's notice?
Yes.
Your lords may see page 9. This is the statement showing the engagement of DLR, NMR employees of in registration organization. My lord, there are 8 columns. Lords, you got it?
Yes.
Your lords may see column number 6.
Yes.
That whether engagement made against sanctioned post or not, if yet copy of such letter to be enclosed.
No. You have taken us to annexure 4,
Yes, my lord, annexure 4 to the writ petition, my lord.
page 9.
My lord.
Yes.
That is the statement showing the engagement of DLR, NMR employees in registration organization. There are 8 columns, my lord.
Yes.
Lords may see column number 6.
Yes.
That says whether engagement made against sanctioned post or not, if yet copy of such letter to be enclosed. Then your lords may see his name finds place at serial number 39. Next page, my lord.
Yes.
Your lords may see R.K. SR Koraput, R.K. Patna, night watchman come sweeper, date of engagement 1/3/2004. Your lords may see there in column number 6 there is a do.
Yes.
Do starts from serial number 30.
Yes. 20.
So 30, my lord. Your lords. Why I am saying 30, my lord? Because
Okay. Yes. 30.
your lords may see, yes, my lord,
That appears to be the,
not sanctioned post.
no, mistake.
No, my lord. 20, your lords may see 21.
From 20 to 29, you say
Yes.
sanctioned by IGR.
Yes,
during
that I want to say.
And this.
Your lords has pointed out that 20, that is correct.
He says no.
Yes.
Not means not sanctioned.
Yes, that I want to point out. From serial 20 to 29, the sanctioned post. From 30,
If it is sanctioned, it is not sanctioned, then
so admit this is his document and he has annexed to his writ petition. Admitted fact, he has not continued against a sanctioned post. So he is not covered under Uma Devi. Second aspect, my lord, state government has formulated a scheme for regularization of DLR and NM employees for continuing for a long time. What that scheme says, those who are appointed prior to 12/4/19, I have annexed that document to my writ appeal, my lord. That annexure 1 to my writ appeal, I have annexed that document. Page 18.
2012.
Yes, ma'am. This is a scheme formulated by the state government for regularization of Group D employees who are appointed prior to 12/4/1993. Admitted fact, this man was engaged after 12/4/1993, that he showed that he has engaged on 1/3/2004. So he is not covered by this scheme also. Neither is covered by the judgment of the Honorable Apex Court in the case of Uma Devi, nor he is covered by this scheme. But the Honorable Single Judge had directed as he has continued against a sanctioned post, and we have not denied. And our specific plea that he has not continued against a sanctioned post. That is the paragraph 10 of our counter. And the document which he has annexed, it shows that is not a sanctioned post. That's my.
Your Lordship, just a glance to Annexure 1 of the writ petition, page 6.
And what about Annexure 4?
That is Annexure 4, Your Lordship. That is what the stand they have taken.
No, they have not taken that.
My Lord.
You had that.
My Lord, have taken that stand. That is, Your Lordship, this is the list prepared by my employer. And in that list, Your Lordship will see that is column number 5, sanctioned by IGR during 1992, Inspector General registration. That is. So far as serial number 39, the name of the petitioner finds place. That is, Your Lordship will see too, that includes, that indicates that I am in the sanction pool.
No, that
but
not.
Not, Your Lordship.
There about that.
My Lord. But Your Lordship will see in the column number 2, that is SR Koraput, that reply is in the Annexure 1, Your Lordship will see. Koraput, Your Lordship will see page 6. Your Lordship just have a glance to Annexure 1 of the writ petition. That is number of night watchman come sweeper. That is sanction post and that is laying vacant. Your Lordship will see that is Annexure 1 page 6. Serial number, Your Lordship, 7. Can see. That has been approved by the IGR, Your Lordship. This is a letter, Your Lordship will see, issued from the IGR to the district register Koraput, Rayagada, Malkanagiri, Nabarangpur. The post which I was holding, that is Koraput, Your Lordship 1, that is sanction post from the year 1992.
That is not the question. The question is that specific plea was taken
My Lord.
by the appellate.
My Lord.
That post is not sanctioned. And single judge has held
My Lord.
that no such plea was taken by them and that the post was sanctioned under the AGR or something.
My Lord.
IGR.
My Lord. I could follow you. I could follow Your Lordship. But Your Lordship will see last column, that is copy and close, that is in respect of the petitioner serial number 39. But what Your Lordship will see, that starts from serial number 30 DSR Korda, that is not copy and close. But here Your Lordship will see that in column number 5. That is my stand. And Your Lordship will see Annexure 1, that is that post has been sanctioned from the year 1992.
Yes.
They have
sanctioned or not, we don't know.
My Lord.
But the post which you were holding
My Lord.
was not sanctioned as per Annexure 4.
But Your Lordship, that is in the Annexure 1. As per Annexure 1, I claim that post has been sanctioned.
Annexure 1, your name is not there.
No, that Your Lordship,
The post was sanctioned. You were appointed in 2004.
My Lord. But my Lord.
Holding a post which was not sanctioned.
But Your Lordship, I was holding that post in the office of the Koraput, that is laying vacant, which indicates that Annexure 1,
That could not have been sanctioned. If you read carefully,
my Lord.
You read the caption. I am directed to invite.
My Lord.
Carefully read.
My Lord. To a letter on the subject and to say that the IGR has been pleased to accept your proposal for engagement of night watchman cum sweeper for the following
bracket.
My Lord.
Bracket you have omitted to read. You have omitted to read bracket.
My Lord. Part-time, that is.
Part-time.
Part-time. Your Lord.
Part-time cannot be
My Lord.
sanctioned post.
For the following, SR office and a remuneration of 300 per month out of contingency. And
Yes,
My lord.
you have a very difficult case, Mr.
My lord.
You have a very difficult case.
Your lordship, I have not yet completed my petition. Your lordship, I will examine it. One more chance may be given. That is.
What more?
That is your lordship. No, what is that ground? This is not the only ground. And another ground your lordship they have taken, that is learned single judge have taken, that similarly situated person, their services has been regularized. And by way of creating one post, that Durga Charan Patnaik, that has not been disputed. Then third ground, your lordship, the annexure one, which has been.
So one person was illegally regularized according to you. One person was illegally regularized.
That cannot claim your lordship. I could follow your lordship.
So therefore, we should follow the illegality.
My lord. But that is in the counter affidavit, your lordship will see, they have not stated anything that is, they have not stated that this gentleman was illegally appointed or his services has been illegally regularized. That apart, your lordship will see, annexure one of the writ appeal, what they have submitted, that is the government circular, that they should have.
No, we will not see
that was not the plea before the learned single.
We will ignore that.
My lord.
We will ignore.
My lord.
Annexure one of the writ appeal we will not refer to.
My lord. That is the first time they are raising this point.
We will not rely on
my
that.
Lord. Now your lordship, the question is whether your lordship is to see, as per the decision of the Honorable Apex Court in case of Uma Devi or ML Kesari, three ingredients is to be seen. That is that person has completed 10 years of service without any interim protection of the post is sanctioned and whether he has the requisite qualification or not. These 3 points. Now your lordship will see that is he has already completed 10 years of service without any interference or interim order of the court. Secondly, he has the requisite qualification because night watchman comes in. That is a class 4. Now, third point, your lordship, which is a hurdle for me, that is whether that is a sanctioned post or not. That is your lordship in so many cases. If that is not, there is no sanctioned post, that amounts continuing them or allowing them to continue, that is the exploitation of labor. That is in that case, your lordship, there is judgment that court will give direction for creation of the post and the services will be regularized.
Mr. Gandhi, have you seen last year's judgment of Honorable Apex Court saying that any number of years of long years of service and a contractual or other? Are you aware of?
No, your lordship, I am not aware of that decision. But that is the landmark decision that is case of Uma Devi and
will not entail you unless there is sanction post. You are working against that sanction post and vacant. So any number of years you may serve, that will not entail you for regularization to claim a regulation.
Your lordship also before your lordship is that suppose your lordship they will allow me to continue or exploit my labor till my death retirement. That is your lordship my predicament. So for that reason your lordship Supreme Court has come for rescue.
Do you know who were exploited? Those who were not engaged on temporary basis. Those who could not be engaged even on temporary basis or contractual basis or on daily wage basis. You were lucky that you continued for so many years.
But your lordship sympathy is not
sympathy.
That is the
sympathy. It does not govern the adjudication process.
Your lordship, urgent to one more chance may be given because
endless.
Some decisions, your lordship, what I will produce some decision. Thereafter, your lordship may pass it on.
You can put up a judgment on 4 weeks.
Your lordship, in the meantime, I will submit on a written note.
Yes, in the meanwhile, you can do that.
My lord.
You too.
My lord.
My lord.
Item number 3 reads to 4 p.m.
So lordship is free to direct them to join on receive lordship. Think whether link markuchan directly.
Yes, which item?
Allow them. Yes. And in the meantime, we have applied the order minutes, we have passed orders to regulation.
No. Just a minute. Item? Item number 3. Where is the order? There is order. Number 3.
Well, your lordships had passed two directions. One
Yes.
was the regularization and one was consequential benefit. Regularization has been done now. Consequential benefits, your lordship may grant us 2 weeks' time, it will be done. My lord,
Yes.
Sincere apology for the inconvenience.
Yes, Mr.
Yes.
May I pray
May I let it come 2 weeks after, my lord, so let the compliance assist.
Sir, they will come. All right, it will come. It will come after 2. Pursuant to this court's order dated, today's order, the additional chief secretary, which department? Minor irrigation department,
Water resources department.
water resource department, government of Odisha has joined online. Stop. Where is the chief engineer? Minor irrigation?
He must be trying to get the link. He's there.
He's joined.
He's there.
So why should we not initiate contempt proceeding against you despite the fact that you have complied with the order?
My lord, we have complied the order due to some treasury restriction
right.
of receiving the bill. We could not proceed. Please pray for time to implement the bill.
A.K. Parija, learned Advocate General, has produced before this court an office order issued today regularizing the services of the petitioner in the light of this court's order dated 13/7/2022. Stop. This said order is taken on record. Stop. He has further submitted that the petitioner shall be given consequential benefits within a period of
2 weeks.
2 weeks.
Great.
Stop. He submits that the executive engineer, then the chief engineer, minor irrigation, Odisha tenders unqualified apology for delayed compliance of this court's order dated 13/7/2022. Stop. Next. Considering the subsequent conduct of the contender chief engineer minor irrigation Odisha, the proceeding Odisha, we are not inclined to proceed with the contempt proceeding for the present. Stop. List this matter on 3 weeks.
Grateful.
The court expects that in the meanwhile, the court's order dated 13/7/2022 shall be fully complied with.
Grateful.
We make it clear that in case of non-compliance of the part of the order, the chief engineer so and so shall be required to join online again.
Let him join.
The courts.
Let him join even on the next date.
All right, if doesn't, if he complies, then
Your Lordship may dispense with the
complies?
appearance of the learned.
and we dispense with the appearance of the additional chief secretary.
From development.
Why are they not complying with, madam, despite your communications?
Sir, they will comply now. They had actually passed one order, but that was a little defective. So today they passed their
All right.
proper. Yes.
All right.
And since you are here, this is not the only case where my lords is very
Yes,
concerned.
please ensure. No, please ask the chief secretary that the consequences may be very serious, which you may not be anticipating.
Sir.
All right. So please ensure that when you don't comply with the court's order, you question the rule of law. Then let there be an order of the court. We will not comply. This cannot be tolerated. The appearance of the additional secretaries also stands dispensed with.
Grateful. But she is also the development commissioner. My lords may say development commissioner, come additional.
Development commissioner. Development commissioner, come additional chief secretary.
Great.
Yes.
My lord, I pray. My lord, I pray a little.
Yes.
I pray for a favor.
Favor?
What favor?
This is being the financial year ending. Treasuries are not receiving bill up to this, up to the end of this month.
Mr. By the time next date is fixed, financial ending year would be ending, and 3 weeks.
We will give you 4 weeks.
So
we give you 4 weeks. All right.
So kind
5
of.
weeks.
Sir. My lord, so kind of. Sir.
5 weeks.
5 weeks रह गया होता.
Sir, April 1st to June.
Okay.
5 weeks. Yes.
Item 24, fixed to 4 p.m.
So this matter where lordships are directed to refund the amount to the leaseholder. Here in fact, the Tahsildar is present in person loss. In fact, he
Item number? Yes.
Revenue department. Now in the meantime, what has happened, all these sources have been transferred to mining department. So there is some problem here. Wait for lordship for some more time so that he can comply with lordship.
Mining department has not received money. The revenue department has received money. Issue of refund is being rolling since April 2022, madam. Lordship may kindly see the previous orders, 20th of April 2022 and your lordship's order 20th of February 24 to be refunded within 4 weeks. It is rolling since April 2022, my lord, and they have been taking time to obtain instruction this way, that way.
What is that order?
Lord, kindly see order of your lordship.
No, forget previous order. Order prior to
Previous
that.
order dated 20th of April 2022, passed in WPC 271-33 of 22. Lord, order number 4. 24th of April 23.
24th of April.
Your lordship's order. 20th of February 24.
No, that I want to see that order.
Lord, that is order number 7. Mr. L. Samantray. Passed in WPC 271-33 of 23. First treatment.
Yes. Where is he?
Yes.
This order was passed in 2023. Why have you not carried out that order?
I surrendered Tahsildar, which is 25, 10, 23.
20?
23, sir. 25 October 2023, sir.
So therefore you are not required to comply with, because the order was passed earlier.
Sir, say my predecessor has written to collector for clarification.
Or?
For clarification of the refund of money.
So both of you want to be punished.
Sir, so the money refunded to
Because in fact, the previous Tahsildar had initiated pursuant to lordship direction, had initiated refund bills. He had written to the collector and so also the state government bills. So because of in the meantime, the amount of the sources have been transferred bills, it could not be material. I've got the letters also of the previous collector, if a lordship sees.
No, see. Do you intend to say that this order cannot be complied with?
I only pray Lordship grant me sometime we'll make it out whether it's revenue of the minerals mining. He will be paid. Your Lordship may grant me 4 weeks time. In the meantime, I ask your Lordship.
4 weeks will not grant. 4 weeks will not grant.
Look, they have been withholding it for more than 2 years. Let them pay interest on this money. At least that may be allowed.
Lordship, 3 weeks will do it. Lordship. 3 weeks Lordship may grant will do it. I ask your Lordship.
There is no coordination between the departments.
No, in fact, so far as return is concerned, because it's taxed with the government minerals, it can be either revenue or minerals mining. It doesn't matter. It can be done minerals.
So no, so there is an order passed by the court.
Yes.
Everyone has to comply with.
Right.
The collector, the chief secretary.
Obviously not. All the parties to the writ application, they are not, even though it's not a content, but it's an order by your Lordship to all the opposite parties to comply your Lordship's order. So I must pray your Lordship grant me 3 weeks time. In the meantime, see that it's paid. It's an undertaking on behalf of him. He has undertaken that he will do it definitely.
In the light of observation made by this court in the first half, the Tahsildar Cuttack.
This is Tahsildar
Ghasipura district Keonjhar
is personally present. So he has submitted that he does not have any intention to disobey this court's order dated 24/4/2023. Stop. He states that because of certain confusion.
Yes, sir.
Certain confusion at the departmental level, the amount could not be refunded to the petitioners.
No, Lordship may say OP6 in this present writ application. See OP6.
OP6? No?
OP6.
OP6.
Opposite parties.
Everywhere it should be.
Opposite party number 6.
In the connected writ application, he is the petitioner. She is the petitioner. And in the present writ application, she is the OP number 6.
OP number 6. So in place of petitioner, it should be OP number 6.
Yes.
OP number 6. Stop. List this. How much interest will you pay? List this matter on 4 weeks. Stop. On the next date, the Tahsildar so shall be required to be personally present for him to report full compliance of this court's order. Stop. As this court's order has not been complied with past nearly 1 year ago, we direct that let a sum of rupees 20,000 be paid to the petitioner. Two opposite parties. In addition to what he is entitled to be paid in compliance of the said order of the court. Yes.
Item 23.
May I please, Your Lordship? As per Your Lordship's last direction, Your Lordship, I have verified the note of the registry, Your Lordship, and as per registry noting, Your Lordship, all have been solved, but restaurant number 10, 12, 25, 26, 27, 33, 34, 35, 40 and 42. They have not been sufficient notice, Your Lordship. I will serve 10 extra copy to the Mullan Senior State Council. They will serve the notice through from department.
Who are the respondents?
Mr. Kuntia, they are working under your department. So to take steps to get those briefs.
Unless he specifies in which department they are working, we cannot serve the
Assistant
copy.
AP under Home Department. APP.
APP.
Yes. That is related matter
Home
related
department रे केमिति रहिबे?
to Home Department notification. Yes.
तଳ कोर्ट रे थिबे ना home.
तଳ court रे.
Then we cannot.
Yes. Subordinate court of deference.
Chief Secretary must be knowing, Mr. Chief Secretary must be knowing where are they serving.
Home.
Oh, we don't know. He must be knowing as to which employee is serving where.
The director of prosecution is now the head of all the APPs. So
All
yes,
right.
through director of prosecution. Can
All
be
right.
solved.
Yes, my lord.
Who are the respondents?
Respondent number 10, 12, 25, 26, 27.
Please.
Yes, I am
State it,
giving a slip.
give it in the slip.
10, 12, 25, 26, 27.
33, 34, 35, 40 and 42 wheelers. 42.
Despite steps taken for service of notices upon all the respondents, notices would not be validly served upon the respondents number 10, 12, 25, 26, 27, 33, 34, 35, 40 and 42. Full stop. The said respondents are working as assistant public prosecutors under the Directorate of Prosecution.
Public prosecution.
Directorate of Public Prosecution. Government of Odisha. Full stop. In the interest of justice, we deem it proper in the interest of justice and for expeditious disposal of the present writ application. We deem it proper to direct that let how many copies?
10 copies, alerts.
Let 11 copies of the writ appeals be served upon learned AGA.
Let him serve on me so that I can communicate
Yes, yes.
instead of office.
No, you,
Yes.
AGA.
Well,
Learned AGA by Monday. By Monday, you do it for him to ensure that the said copies are transmitted to the
Director of Public Prosecution.
Director Public
Prosecution.
Full stop. That soft copy you can provide.
Yes, Lord.
That can be easily communicated. All right, do it.
Let him serve one copy so that from LMS we can send it, my lord. Let him
Yes.
serve one copy.
One copy.
My lord.
One copy. What should we do?
They have litigation management system.
The writ appeals must have been sent to you.
Yes, my lord. Yes, my lord. I'll.
The soft copy of the writ appeal must have been communicated to you.
Not sub. They're serving it a hard copy.
No,
Yes.
your LMS.
LMS.
Your
Yes,
LMS
yes.
already would have.
I will
made
communicate
a
all this to the Director of Prosecution by Monday.
So you serve
Only
one copy.
my lord's order.
For abundant caution,
My lord.
he will take.
One copy. When my lord's.
Instead of 10, 1.
Thank you.
May pray item 34.
Yes.
2 weeks after may be called.
2 weeks. Yes.
Item 28. It have been filed. It was had without notice. I still admission. No counters filed with us. No receipt notice is return. So it was permitted. I can file a counter and merit of the case in this thing. I can show it time to. Item 48. It was dispatched admission. The file data bit. Notice here. But our side story was not there. Good thing is let me file my counter with all the facts. They don't read it, so that one can decide or if we were able to matter to them. I have my.
Let that come. Let that come.
Item 28.
Let the matter be called first.
Item 32, your lordship, it can come first week of April. And otherwise it would have come tomorrow as the inconvenience.
All right.
First week of April.
All right. I'll also not come tomorrow.
37, if your lordship permits. 36, my lords.
Yes.
Can it come on the second week of April? Once we are
Is that
preparing.
going down?
No, we are preparing a rejoinder.
Okay, do that.
The petitioner, just that prayer, small prayer.
When?
Second week of April.
Second week of April.
My lord, meanwhile, in that matter, 36 only, we want to intervene in that. Maybe I've granted us liberty.
Want you can do. We don't know.
Liberty meanwhile.
See, every person has right to write letters and file petition. It depends how the letter is to be treated or the petition is to be dealt with. We'll see. Unless there is some bar, you can do that. We are not stopping you.
Grateful. Great.